May please allow. But see, with respect to item number three, that matter relating to contact of Ketchum University. I was supposed to produce report. But see, my play that matter taken on Tuesday also. So the registrar as well as the DC is out of station. Assam, Tezpur University. Right? On Tuesday. See. Has
Indian order pass earlier that continue.
much of
Mention item number 27, Lordship. The concern of other side.
Yeah, Lordship, there is some compromise talks going on. So may I pray for 3 weeks time? It's moving in the opposite. Actually, there are lots of accounts that have been taken care of. Deeply obliged.
Wait, please, my lord. I beg to mention one matter for listing, my lord. It is still in motion stage, my lord. It came up last year, my lord. Last it was listed on 6/10/23, my lord. It is pertaining to the issuance of next of kin certificate, my lord. We are challenging that, my lord. There are certain discrepancy in that. My lord, it is in dispute, my lord. They have misrepresented certain facts and issued the next of kin from the DC, my lord. It is still in motion state, my lord. In fact. My lord, on 13th, my lord. Highly obliged.
My plea, Lord. My lord, this matter last listed in the month of January 2023, my lord. So it's not being listed since then. May I pray, my lord, any date, my lord? Lord, deeply bless you. Lord.
May I please, my lord, I beg to mention item for listing of IA, my lord, for correction, my lord, kindly Monday, most of it.
Lordship, kindly allow this matter for listing. Matter relates to non-payment of contractual bill. 25. Okay.
Yeah, please, so Lordship, I beg to mention item number 17. As my senior is currently out of session, matter may be fixed at in 6. A similar matter were also fixed on 6. Yes.
That please, Lordship. Lordship, I beg to mention item number 26. Lordship, 2 weeks time may be granted for filing affidavit in reply. A. Ahmed. Lordship, we have already made it ready. We sent to the party. He's from Siliguri. He has to sign and. Deeply obliged.
May I please? This is the contempt for non-compliance of the order dated 5/5/2022, madam. A Boro, madam.
Obliged.
May please your lordship. Well, the swanton of police, Golpada. Well, the bill they admitted, well, the test, well, 14, madam, 1 4. Yes, but the swanton of police, well, they provide this form, my lord, and after fill up, they have acknowledged, my lord, by receiving this seal and sign, my lord. So this may be issued, one. This way they have received the bill, ma'am.
Otherwise, also admission part is not there, bill is there also. Lordship. Even yesterday also, Lordship said, directed them to file a RTI, obtain admission part loss.
Which bill have submitted on my lord, several bill, my lord. One bill is 17/12/19. My lord, 14. There's 14, my lord, 17/12/19. Again, my lord, another bill that is 3/2/2021. Next bill, my lord, that is page 20. Here also, my lord. Date, my lord. Page 14, my lord, that is 17/12/19, my lord. Well, they have, well, accept on so and so. Where is seal is there? Above, my lord, the right side of the. Well, this form they have provided, my lord. Actually, this is the form provided by the SP office, my lord. And the petitioner fill up the form and submitted it. Yes. Lost.
I am for all the. All the.
Malad, 5, 6, 7 similar. Yes. Not 8, madam, up to 7. Yes. Madam. Yes, madam. Obliged.
May I please, your lordship. Lordship petition pertaining to lordship, bill lordship. Lordship, kindly see page 23, lordship. In connection with the supply of school uniform, lordship. It's a date 27 for 2021. Page 27, lordship. Lordship, I beg to draw your attention, page, lordship, kindly see page 21. This is the guideline, lordship, issued by the Sarva Shiksha, mission diagram Sarva Shiksha. The mode of payment, lordship, kindly see page 21, bottom portion, lordship, alphabetical D, payment and maintenance of record, lordship. Serial number 1, the payment to the supplier must be made through account payee check only, and no payment will be made in cash. And lordship, the respondent authority, lordship, provide lordship 50,000 check. Lordship, that I have an extra, lordship. And remaining portion, lordship, has yet not been given, lordship, even though lordship only 50,000, lordship, kindly see page 24 and extra 3. This is the check, lordship. It will be an SMDC question.
SMDC is not under the SSA.
Lordship,
SMDC, it is a school management society.
yes, yes. Lordship,
That manner, again, is not a government authority, SMDC. So to claim a no, SMDC is not.
yes, government authority, lordship, kindly see page 16 annexure 1.
Society house.
Issued by the mission director to the principal secretary and all DC, lordship. And lordship, subject, a guideline on procurement and distribution of uniform for a learner of elementary level for the financial sense of. Lordship, I am reading, lordship, the contents of the letter in enclosing here with a guideline on procurement and yes, lordship. Lordship, kindly see page 22 annexure 2. Yes, sir, lordship. SMDC, yes. And SMDC has been entrusted empower, lordship, for disbursement of fund as per the guideline, lordship.
What is SMDC?
SMDC, school development management committee, lordship.
It's the council. What is this school? This is by the
High
school.
High school, lordship.
It is not,
High school, lordship.
it's not a government school, is it?
Yes, lordship, provincialized school.
You go, I don't think this is,
And
no, you go to the civil court.
lordship, earlier occasion, lordship, petitioner,
Heard, Mr. What is your name?
yes, Ali, lordship.
Yes, Ali. I'm discussing it. You go to the civil court.
Lordship,
This is between two private parties. This is not against government.
no, lordship, no private, lordship. School headmaster.
Right, we
headmaster,
heard
they-
Mr. S. Ali Lennox Council for the petition to submit that the president of the
Lordship, there is a lordship is
President SMDC,
the district elementary
comma,
education officer,
Dakalia,
lordship.
Dabalia Para High School has issued a supply order for school uniforms on 2/3/2021. It's The petitioner thereafter supplied the school uniform to the respondent number 5 school. And submitted his bill amounting to rupees 3,18,000. While the respondent number 5, that is the while the respondent number 5, that is the headmaster of Dakalia Para Dabalia Para High School has issued a check of rupees 50,000 to the petition. The balance 2,68,000 has not been paid to the petition. The petitioner submits that the petitioner has submitted a representation dated 11/3/2022 to the respondent number 4 for release of the remaining bills. The remaining bill amount of rupees 2,68,000. However, the balance amount has not been paid to the petitioner. Mr. B. Gogoi, Learned Counsel for the
3 and 4.
for
2, 3 and 4.
2, 3 and 4 submits that the issue pertains to the Dakalia Dabalia Para High School and the petitioner. As such, the issue does not involve the state government, correct?
My lord,
No, lordship, lordship, more for a moment, lordship, kindly see page 31, annexure 6, lordship. This is the block elementary education officer issued a letter to the headmaster, lordship. And the district elementary education officer also made a party. School is a provincial school, not a Bensar school, not a private school, lordship. Lordship issue, notice may be issued, lordship, at
no, my
this
lord, in
state.
fact, in a similar case, my lord, page 29.
Yes,
The direction was to the, my lord, headmaster to consider the representation of
Yes,
similar.
yes. Yes.
no, I'm not going.
Yes, my lord.
To
That-
submit, right. On perusing the on perusing the writ petition, I find that the issue pertains to supply of school uniforms and payment of the bill between the petitioner and the said school, huh?
Yes.
There's an alternative remedy available to the petitioner by way of approaching the civil court. And as the limitation period for approaching the civil court has not expired, this court is not inclined to entertain the present petition. The writ petition is accordingly dismissed, with liberty being given to the petitioner to approach the appropriate civil court. Okay, we can do it. We can do it.
Item 9.
Yeah, please, your lordship.
Yes, what is your case?
My lord, in this case, my lord, my lord, in this case, my lord, I am the wholesale license holder, my lord. TTS
You are the
wholesale
wholesale license holder.
Holder, my lord. My license has been cancelled, my lord, due to several allegations, my lord. Page number 26, my lord. Kindly see, my lord. There are each and every page there are.
Just a minute, where are you?
My lord,
Wholesale license holder for what?
for PTS, my lord. PTS articles, my lord, sub
Okay.
wholesale license, my lord. And my license has been cancelled, my lord, page number 37. This is the impugned order, my lord. My lord, each and every page there is a violation, my lord. I was not heard. There is a violation of clause 15(2). And inquiry report was not furnished, my lord.
Can I third, mister?
My lord, in this case, lordships, where the appeal provision is there, lordship.
Huh?
Appeal provision is there as per rule 29, lordship.
We have filed also appeal, my lord.
You file an appeal.
My lord, my
Then
lord.
lordship, matter.
Then if you file an appeal, then we'll tell,
This was not
So let
considered,
it-
my lord, till
huh?
till it is pending before the authority, my lord.
No, it's appeal.
Page number 38, my lord.
38, it is not an appeal, lordship. Appeal should be the commissioner secretary to the food and civil supply, lordship. It is before a deputy commissioner.
Deputy, my license has been cancelled by the assistant director, my lord.
Otherwise also, if he is preferred appeal, then lordship, petition lordship.
And my lord, there is no,
No, you see, the appeal has to be made before the,
If it's assistant director of food and civil supply, then deputy commissioner. Then lordship, it is deputy commissioner.
so he has made it to the district commissioner.
Lordship, then lordship, if petition become infectious, lordship, because it's preferred an appeal, lordship.
it is still pending, my lord. There is
The
no.
thing is another thing,
consideration.
then lordship, the preferring a writ petition.
So we'll direct the district commissioner to,
Consider my appeal.
to take a decision on your
My
appeal.
lord.
Right. Heard, Mr. F. A.
hello.
Laksa, learned counsel for the petitioner who submit that the petitioner number one is the secretary of MS Nitai Nagar GPSS Limited in the district of Hailakandi. While the petitioner number two is the said GPSS Limited. Super. The petitioner is agreed with the order dated 15/9/2023 issued by the Assistant Director, in charge Food Civil Supplies and CA. Wherein the sub wholesale license bearing number HS PDS/H/W/6 issued to the petitioner number one has been cancelled in exercise of the power conferred under clause 15(1) of the Assam Public Distribution of Articles Order, 1986. The petitioner's counsel submits that an appeal has been submitted to the district commissioner, Hailakandi, against the impugned order dated 15/9/2023 in terms of rules or what is this? Order 29. Order 29 of the Assam Public Distribution of Articles Order, 1980. So, however, the same has not been disposed of by the District Commissioner Hailakandi till date. The petitioner's counsel submits that the present petition can be disposed of if the District Commissioner Hailakandi is directed to dispose of the petitioner's appeal dated 13/10/2023 within a specified time period. Mr. K. Gogoi, learned counsel for all the respondents submit that he has got no objection
Lordship,
to the prayer made by the petitioners, comma. Next. In view of the consent of the parties, comma. The district commissioner Hailakandi be directed to dispose of the petitioner's appeal dated 13/10/2023 within a period of 1 month from the date of receipt of a copy of this order. And communicate the decision taken to the petitioner. That is petition is accordingly disposed. Obligation.
May it please your lordship.
Yes.
Lordship, we are basically challenging the impugned notice of termination dated 17/2/2024 issued by page 35. Annexure 2, my lord. And also, we are challenging the auction process, lordship. That is at page 37. 37 is the type copy and the 36 is the original copy.
Why are you challenging?
Lordship,
Your
in this
termination.
case, my lord,
Huh?
they are basically going to auction my tender, my lord, my agreement. The agreement is executed between the parties for leasing of parcel van. That is, lordship, will be effective from, lordship will be effective from 14/7/2022 up to 11/7/2027. This will be valid for
From
5 years.
14/11,
14/7/2022 up to 11/7/2027. This agreement is valid for 5 years, my lord. Now, lordship, in terms of this letter, they are going to terminate my contract, my lord.
what ground? Why?
They are saying that, my lord, the two pair of stations which were agreed in the agreement, that is, my lord, they are basically allowing us to transport parcels from Kamakhya to Lokmanya Tilak terminus and again back from Lokmanya Tilak terminus to Kamakhya on round trip basis, my lord. So they are going to extend that Kamakhya to Agartala, that station, my lord. So now, my lord, we are saying that we do not want to extend that portion because we do not have such traffic, my lord. We do not have business in the that state.
Agartala.
Yes, my lord. So we are basically just denying their proposal, my lord. So in terms of that clause, my lord, 21.1, they are going to terminate our contract, my lord. But they cannot do so, my lord, in terms of clause 17 of the agreement.
What does clause 17 say?
17 is at page 60, my lord.
60.
Yes, my lord, 60.
Yes.
My lord, clause 17, extension of train or increase in frequency of train. In case a train in which parcel space has been leased out is extended beyond its initial originating station or beyond its initial destination station, then the leaseholder will be permitted to continue his lease between the pair of stations mentioned in his contract. It will be assumed that the lease is being operated to from an intermediate station as the case may be. This arrangement will continue till the expiry of the contractual period in the normal course. Again, my lord, 17.3 is very relevant. However, in case the existing leaseholder is not prepared to extend his lease beyond the starting and terminating stations for which the contract has been executed, then the divisional zonal railway will be at liberty at float fresh tenders for the newly extended portion. So in terms of clause 17.3, though the divisional railway has the power to float a fresh tender, but that confines to only to
The
extended portion,
extended portion.
not to the pair of stations which they were agreed for, my lord. And in terms of clause 17.1, the leaseholder has the power to continue this contract, my lord. They cannot terminate it. But in terms of clause 21.1, they are basically saying that we are going to terminate your contract
What does
because you are
21.1 say?
21.1 says, my lord, it's at page 62. Railway shall have the right to terminate the contract or agreement for any reason whatsoever after serving 1 month's notice to the leaseholder. However, railway shall reserve the right to terminate the contract as a punitive measure without any notice and at any time in case of breach of agreement or serious violation of any of the stipulation of policies, railway rules by the leaseholder or in case of operational exigencies. However, such instantaneous termination of contract by railway administration should be followed by a written intimation of breach of contract within.
Anyway, right, so there should be a breach of contract. Basically.
Yes, my lord.
So basically, right
One
now,
more point, my
yes.
lord, I would like to add. This railway has the power to serve notice 1 month prior.
uh-huh,
But here in this
No
case, my
notice.
lord, they had served notice on 17/2/2024. They did not give us the opportunity to present our case. Now they are going to terminate our contract and they are going to auction our parcel when on lordship today they are going to auction it at 11:30, my lord. So 1 month time is not provided to us in terms
where is
of
the notice?
notice.
Okay, that page 35.
Yes,
1 month's time has to be given
yes.
as per 21.1.
Yes, but now today they are going to auction our, my lord, contract, my lord.
Where is your contract agreement?
My lord, contract
Well,
agreement.
Yes,
Contract agreement is at page, my lord. Forty-seven. Annexure 10. Roman 10. Further, they have also violated clause 25, my lord, 25.2.
from Kamakhya KYQ to Lokmanya Tilak Terminus
Yes,
and then back to Kamakhya.
yes,
It's under this trade, this is only in this train number, this specific train that means,
yes, my lord.
or one train.
One train. That is train number 12520.
12520
Yes.
and 12519. That is return is 12519 or something.
Yes, my lord. That will be, my lord, valid for 5 years, my lord. So my agreement is valid up to 27, my lord.
Where is the period given?
Period is given at page 48, clause 1.0, my lord. 1.1 is specifically mentioned about the period, my lord.
17/7/22, madam, not 14/7.
My lord, from Kamakhya, it will be effective from 14/7/2022,
Okay,
and from Lokmanya Tilak, that is will be effective from 17/7/22.
Okay.
Again, from to
Okay,
Kamakhya,
anyway.
it is 8/7/22.
yes, Mr. K. Gogoi.
Otherwise, lordship, they have prepared an arbitration also. Arbitration clause is there, lordship. They are,
Actually, we-
Maybe,
lordship,
but in the meantime,
lordship.
what's happening is you have violated your own provisions, your contract agreement.
Otherwise, lordship, that page 37 says that auction only extension zone, lordship. Page 37,
Correct.
lordship.
Now, you see, there's the contract agreement between you and her, the
Lordship.
petitioner,
Lordship,
that the parcel van will go from here to here and
Lordship.
back
lordship.
for 5 years. Now you are saying, instead of here, you go here also. He's saying, no, I don't want this portion. Because of that, there is
As
no
per
co-
auction notice, the auction notice only for extension zone, lordship, not.
Is it?
It is,
No, my lord,
Lordship.
because they are serving
us
us
even
a
when is the
termination
auction notice?
notice. Yes.
lordship, page 37.
37.
37, lordship.
Yes.
37, lordship. Auction catalog, lordship, my lord may kindly see auction extension zone only.
Auction
Extension zone.
Where is that?
It is
Auction
for-
extension, yes.
Yeah, only extension zone. So lordship may give 1 day time, I will obtain instruction.
No, lordship.
No,
today they
we'll
are-
give you time, but then we'll stay the thing.
Otherwise, it is extension zone, only extension zone.
You clarify that.
It
In
says
the
that-
meantime, you do not settle the things, right?
Otherwise, it's arbitration is already CS, lordship.
Maybe,
Lordship.
but then it
And
doesn't mean that just.
And auction catalog also shows that, lordship, not the whole route, lordship, only for extension zone, lordship.
We'll see, just because there's an arbitration clause, doesn't mean that it has to be sent to
I am
arbitration.
not going to the arbitration clause, lordship. I am going to the notice of the auction, lordship.
Just go there.
It says that, lordship, only extension zone.
And anyway, you do that, it should not, you cannot, but you
Not,
cannot.
disturb in respect
Yes,
of their,
you don't
otherwise
disturb
auction zone is, extension zone is.
Heard, Miss
I'm Sharma.
M. Sharma, learned counsel for the petitioner, who submits that a contract agreement dated 31/8/2022 has been executed between the petitioner and
And the respondents, railway.
all the respondents
My lord, it is between the petitioner and the respondent number 5.
and the respondent number 5 for leasing of parcel space in parcel LVPH by train number 12520 dash 12519. Kamakya, page 47, huh? 47, red to red, okay? So, sir, the period of the contract agreement was from 14/7/22 to 11/7/27. So, sir, the respondents thereafter made a request to the petitioner to operate the parcel van up to Agartala. Correct, Agartala from KYQ or what, from where?
KYQ is Kamakya.
Okay,
Station.
from
Kamakya to Agartala.
KYQ to Agartala.
Yeah,
That's
the
right.
extended. route.
Extended portion.
That's what. For some. However, the petitioner communicated its inability to operate the extended portions from KYQ to Agartala and reiterated that it would fulfill its obligation in terms of the
Clause 70.
contract agreement between between KYQ and what is the other one?
Agartala.
No. KYQ and Agartala is
Lokmanya
extended.
Tilak Terminus.
What is that? The short form of that?
LTT.
L
TT.
LTT. Full stop. Next para. The petitioner was thereafter issued 1 month's notice by letter dated 7/2/2024,
17 to
17/2/2024 by the respondent due to the petitioner not accepting the extended route communicated by the railways to the petition. That is beyond the route provided in the contract agreement. Next part. The petitioner's counsel submits that the 1 month's notice issued by the respondents for terminating the contract agreement between the parties is in violation of clause 17.1
and
17.3 of the
agreement.
agreement. So besides the above, in terms of clause 21.1,
Yes.
1 month's notice had to be provided by the railways to the petitioner for breach of contract, intimating the breach of contract. In this present case, there is no breach of contract. And even though 1 month period has not expired, the state respondents, where is that notice, have issued
Notice for
for tendering the thing.
Lordship, that is at page 37. 37 is the type copy.
They have issued the what is this? Auction catalog.
Auction catalog, my lord.
Have issued the auction catalog.
Number is there, my lord. Lease -LMG -02-24.
Yes, auction catalog, LEAC lease dash LMG dash 02 dash 24.
Lordship, I am just clarifying one thing, Lordship. I have indicated option extension zone. It is the time, Lordship, not
Okay.
time, because the above, Lordship, option close date and time is there, Lordship. Only one.
Anyway, this is a submission.
Lordship.
Whereby the railways are now attempting to are going to auction off the entire
LVPH, parcel van
the entire parcel van,
on
entire parcel van from KYQ to LTT. Even though the same is still, even though the contract agreement is still valid till 11/7/27. He submits that the auction is going to be held today
today at
Yes, sir.
11:30.
at 11:30 AM. Mr. K. Gover, Learned Counsel for the Railways,
Lordship.
submits that he needs to obtain instructions with regard to the above. Next para. A perusal of the contract agreement made between the parties show that the agreement has been made for leasing of parcel space from KYQ to LTT for a period of 5 years, which is to end on 11/7/27. There is nothing in the notice dated 17/2/2024 showing that there has been any breach of contract on the part of the petitioner. In fact, it appears that the respondents are trying to force the petitioner to undertake an extended route beyond the route provided in the contract agreement. Even though the petitioner is not willing to act on the request of the respondent. Clause 17.1 and 17.3 states as follows. As page 60. On considering the above clauses and the notice dated 17/2/2024. This court finds that this court is of the view that the petitioner has made out a case for giving an interim relief to some accordingly. The operation of the impugned notice of termination dated 17/2/2024 issued by the respondent number 5 is hereby state. Till tomorrow? No, not till when?
Lordship, why Monday, Lordship?
That
And-
Monday,
When-
Monday,
when
okay,
is
till Monday, huh?
Lordship.
Till Monday. Further, the auction process initiated through online via auction catalog number. These LMG 02/24 dated 15/2/2024. For lease of train number 12520/12519 AC Express. Oh, that is in the prayer.
My lord,
Is
may
also-
indicate Kamakya to Lokomanya to
For the, from KYQ
KYQ
to
to
LTT,
LTT,
to
Lordship.
LTT,
Lordship.
to LTT is hereby state. Till the next day.
Lordship. Otherwise, Lordship, there is an option for so many trains, Lordship.
Yes.
Lordship.
Deep problem.
This is the matter on Monday.
Lordship, lordship.
But you'll have time on Monday? I don't think so.
Oh, Wednesday, lordship.
Wednesday. Wednesday.
DP obliged.
Oblige, lordship.
May I, lordship, matter pertaining to non-payment of contractor bill, lordship.
What are the source?
Lordship, Jal Shakti is also a party. The liability statement,
Any, what is the latest?
yes, lordship. Monday, lord.
Yes,
Yes, sir.
in terms of that order, right? Wait, out here, it'll be. Out here, I heard Mr. K. Kadri, that's it. And who's for CGC? Mr. K. Gogoi.
For one, lordship.
K. Gogoi, huh? Then, you have,
2, 3,
in
4,
your
5,
name,
and 6.
madam, your name, huh?
TJ.
T. Jain,
D.
D for Delhi, D. Jain. For 2 to 6.
Yes, your Honor.
Just a minute, out here will be different. So the, out here, the petitioner,
Lordship,
correct? So you paid a certain sum of money.
yes, lordship.
And how much, what is the balance now?
Lordship, it's 12,75,000
12 lakh 78,000
75,129
529.
is the balance amount.
So you are a registered contractor.
Lordship.
Morrigan.
Morigaon, lordship.
So the out here, the, what is the contract?
Lordship, same
No,
scheme.
no. Out
Various
here, what
work
is the
order,
work?
various work
Work
order,
is under this scheme.
same lordship, RS to T, same scheme. Name of the scheme is
No,
same.
scheme is different. RS to treat dike along with Charyagi. Okay, same.
Same, lordship.
Okay, so this is same. So where is the letter admission?
Lordship
Liability.
is page number 15, lordship. The liability statement and relevant portion is in page number 16.
This is again, liability statement. Where is the forwarding letter? At page 13.
Lordship. It's the RTI reply, lordship.
Anyway. By letter and so 205, same letter. No, out here is different. 1535. Dated is 6/8/23. Liability say, where is the amount?
That's about page 16, lordship. Last column is the balance amount.
12,75,129. And Miss DJ.
DJ.
Okay, as per, I have made the correction here.
No.
It's it. Just follow this.
So item 11 is also similar matter.
Again, as we, you just print out another copy.
12, Lordship.
Twelve.
12 and 15, they are similar matter.
But every,
The amount is different and petitioner is,
and the Morrigan again will be different. The letter,
Lordship, it's
foreign.
Morrigaon and scheme is same.
scheme is same.
Yes,
But
Lordship.
then the letter will be different, letter number will be different.
Lordship.
You just check these numbers, wherever I put red, no? Just check that. Ah, yes. You give me another printer, just take out this printer.
I have,
976 of 2024. You have got another one?
yes,
Just give me another one.
I will apply.
Yes, just give me the next case. Item 12. That's one.
12
15 also is there.
and 15, Lordship.
Okay, just a minute. Fairness. D. How much is the amount in this item 12?
Lordship, it's 12 is 4,59,000.
How much? 4 lakhs?
4,59,168. That is at page number 14, Lordship.
Okay. Let us see the letter of the.
Yes, Lordship, it's page number 12. It's the RTI.
Page number 12. Okay. One, 9, 11, 23. Amount is again 4,
59, Lordship.
59,
168.
168.
Yes. Lord. Page number 14.
Yes. Okay, then what is the next item?
Item 15, Lord.
Huh?
Item 15.
Give me 15. Give me another order. Unless we do that, she'll get confused. No, I just want to see. It's the same.
Same scheme, Lordship. This is page number 15 is the liability statement.
How much is the amount?
It's 10 lakh, Lordship.
10 lakhs?
10 lakh 47,521.
Where is the E letter,
Page number 13.
Okay.
13A.
13A.
ten lakhs,
47,521.
mm, just give me the item 12 again. There's some correction I could do. Party's name will change, case number will change. Okay. Yes,
Okay.
Happy, sir. Sir, by letting to non-payment of bills for supply of some stationery articles,
when did you supply?
2018 Lordship,
18.
18.
Okay, right. Heard, mister?
There is no admission, my lord.
Maybe, but the problem is now he's got no alternative remedy. Even if he files a money suit, he's got limitation bars him now.
That may be, my lord, but some documents at least.
You obtain instruction. You see,
I
now,
can do that.
you see, where people have still got time to go to civil court, that we may be strict.
I can understand it.
But now he's got
In
nowhere
fact,
to run.
Case number 38, my lord.
Ah.
His name is, the firm's name is not there, my lord.
Where?
Case number
38.
38.
Yes.
Last case. This is the copy too, my lord. There are some proposal they have sent government, my lord.
I know you obtain instruction. Heard, mister?
10 not Lord.
A. Ahmed.
A not.
A. Nath.
Not.
The counsel for the petitioner who submits that the petitioner had supplied various materials to the office of the deputy commissioner Nalbari for the panchayat elections held in 2018. The supply bills amounting to rupees 3,82,934 have not been paid till date. Issue notice returnable in 4 weeks. Mr. S. Datta accept notice on behalf of.
My lord, problem is that, phase, respond number 2, my lord, there is no such post, my lord. Commissioner and Secretary, Panchayat and Rural Development, Panchabari, my lord, there is no post called Commissioner and Secretary, my lord.
So what post is there?
So, in Panchabari, my lord, Commissioner is Commissioner, and in the government, it says Secretary, my lord, or Principal Secretary.
So you see, what you can do, there are two aspects. Either you can file an application for amendment of your writ petition, or you withdraw and file a petition. Then we can issue notice later.
I mean, permitted to correction.
No, that is not allowed anymore. Because now that was allowed earlier. But now because the system doesn't allow you, the CIS system, we cannot upload it, cannot be uploaded. That's why now there is a notification issued by the High Court that for all corrections, modifications, everything, you have got to file an application. And once that is allowed, you can file a amended petition. But the easiest way out is you withdraw with liberty to file afresh, or you can file a amendment application. Mr. A. Nathan, counsel for the petitioner, says that he may be allowed to withdraw the writ petition with liberty to file afresh. Praise the Lord. The writ petition is dismissed and withdrawn, with liberty of fixed. So you make it two points. State of Assam represented by secretary, so, and that commissioner, you make a separate one.
In this case, my lord, I have filed this instant writ petition, my lord, challenging the NIT to NIT, my lord, without countersigned by the higher authority, my lord, and without online basis, my lord, without countersigned by the conservator, my lord, higher authority. Because DFO has published the, my lord, NIT, and there is no signature of the higher authority.
Is it required?
Yes, my lord. it is required.
Where does it say it's required?
And also, my lord, above.
No, no, first you answer the question.
Yes, my lord.
Where does it say that the conservator has to sign?
That provision is at present not with me, but another notification I have annexed here. If it is more than 20 lakhs, it should be, my lord, online basis. But manually he has published, my lord, DFO. That notification I have annexed here, my lord. Then
So if it is above 20 lakhs,
20
it
lakh.
should be online.
online, my lord.
And if it is below 20 lakhs,
Yes.
it should be.
It may be, my lord, by way of manually, but here it is specifically mentioned in Annex 3, my lord, page 37.
And supposing he has done it both manually and online, then what happens?
Then also, my lord, here, my lord, he has mentioned, the DFO mentioned in the NIT, specifically mentioned it may be tender has to be my lord, bid has to submit, my lord, in the Assam tender my lord, online basis. But that is not. It may be, my lord, government, www, government tender, Assam tender, government in basis, my lord.
Have you participated in the tender?
Yes, my lord. Obviously, my lord.
You participated.
I have
and
participated.
now you're challenging the tender process.
Yes, because, my lord,
You are,
here, my lord, in the,
you're unsuccessful.
no, my lord, can you, just I'm
No,
listening,
no.
my lord.
No.
No, my, here, my, in the, at the time of,
is unsuccessful. I have the minutes.
Okay, that's why you challenged it.
no, my lord, my prayer
And
is
he,
just-
my lord, initially, my lord, he challenges 2 tenders in 1 writ petition. He challenged two NITs in 1 writ petition.
Yeah.
And I have the NIT also, I have the CS also, and it was floated online in Assam Forest online manual,
Okay.
online note manual. He says it should be an Assam government, but it is also a government portal space. That is his.
but that clause is, my lord, here is specifically mentioned in the office memorandum, and also, my lord, because at the time of, my lord, tender form when we collected, my lord, the tender form, there was no clause, my lord, of court fee. But in the subsequently NIT published, that court fee clause has been, my lord, published, my lord.
Let us go one by one.
Yes, my lord.
First of all, you are challenging 2 NITs in this
Yes,
case.
my lord.
Is it pertaining to the same cause of action or different cause of action?
Different cause of action.
File 2 writ petitions.
My lord, first, then, my
First
lord,
of all, you file 2 writ petitions. You cannot have.
second one, my lord, I'm not pressing them the second one, my lord, because I have participated
Okay.
in the first one. More than 20 lakhs. But
You have participated in the first one.
first one, my lord. But
So you are challenging only the first one.
first one, because
Second one, you're not challenging.
not challenging, because, my lord, that was
Wait.
not-
Let me write down your. Let me write down your submission so that I don't make a mistake.
Yes,
Mr.
my
Ram. Mr. H. Das.
Yes.
Learned counsel for the petitioner. Submits at the outset
Yes,
that he does not wish to press
yes.
his challenge to the NIT dated
Annexure for 28/12/23,
28/12/2023.
not publication, not published
Full stop.
properly.
His only challenge is to the selection mates. Correct?
Yes, my lord. Not
Uh,
selected.
His
but
his
NIT
only
published.
challenge is to the impugned NIT dated 9/12/2013.
23.
23.
Yes.
That's all, correct?
Yes.
Uh,
That was
Now-
not published.
Now, what is the ground of challenge to this 9/12/23?
My lord, it is Annexure 3, my lord. Office, my lord, kindly peruse your lord.
Page.
Page, my lord, 37. Para 4.
Para 37.
Yes,
Yes.
page 37, Annex 3. Here henceforth all administrative department of government of Assam and its subordinate directorate officers, agencies,
Just a minute, page 37.
page 37, Annex 3.
Yes, from henceforth, okay.
Yes, madam. Henceforth, all administrative departments of government of Assam and its subordinate directorates, officers, so and so, including institutions, so and so, shall adopt e-procurement, HTPPS, so and so, for procurement of all goods, services, and works for all tender of value of rupees 20 lakhs and above.
So
is-
this, in this tender notice
Yes, madam.
of 9/12,
No mention.
what is the amount?
Amount, my lord, 28 lakhs, my lord.
20.
28 lakhs, my lord, 59,850.
So,
Page 19, page 19.
Huh?
Page 19.
28 lakhs, 28,
Yes,
59, 850.
50, my lord.
So, according to you, so
Hmm.
it was not published online.
Yes, madam, online. That clause is not mentioned here.
What do you mean not mentioned? Was it, how did you get to know of the tender notice?
Page, my lord, that is page 36.
So it was advertised
Advertise.
in the newspaper.
Yes, ma'am. Sentinel.
So you got to know of this
Yes.
NIT
After receipt of,
through the newspaper.
yes, madam.
You submitted your bid
Yes,
and you were not selected,
not selected.
not selected. And now you are challenging this NIT
NIT, madam.
on the ground that it
Not-
was not
Not proper publication among the public. That clause is not there. Court fee clause was not there.
publication not done.
Yes, my lord. Not
Uh,
court fee clause was not in the
Huh?
NIT.
What was not done?
Court fee clause.
No court fee clause.
Yes, my lord. In the
Okay,
tender
one
form.
is no court fee clause.
In the tender form.
In the tender form,
Yes, my lord.
in the tender form. In the tender form. Then next,
And next one is my lord, that court fee clause was, my lord, mentioned in the NIT. It was circulated among the public 27
you just now said there's no court fee clause in the tender form.
tender form. But they said about the court fee in the my lord, NIT. Mentioned in the
Court fee mentioned in the NIT.
NIT.
Court fee mentioned in the NIT. Then
Yes,
what else?
these are the my lord grounds.
Three grounds.
Yes, 3 grounds, and also not countersigned by the higher authority. It has
Not countersigned. What was not countersigned?
by the conservator, my lord.
No, what the advertisement, the NIT, what is supposed to be countersigned?
Countersigned by the my lord.
What has to be countersigned? Your checkbook or what?
The NIT, my lord. At the time of
NIT.
publication- Yes, my lord.
NIT not countersigned by
Conservator of forest.
NIT not countersigned.
Above than the my lord DFO.
Countersigned by conservator
Yes, my lord.
of forest.
Yes, my lord.
Now,
The DFO published, my lord, manually.
okay, show me the rules which says that it has to be countersigned by the,
That is at present not with me, but I.
not
can-
with you.
At present, that is not with me as per the verbal instruction from the client, my lord. I have mentioned here, my lord, but it has to be. Anyway, my lord, and so far notification is concerned, I have annexed here, my lord. Regarding that above 20 lakhs, it has to be in the, it has to be, my lord, www.assamtender.government.in.
It has to be in
www.assamtender.government.in.
www.assamtender dot government,
And gov,
full,
GOV.
gov.in.
Yes, my lord. They have published www.
This is again from your client's mouth of we have.
Here it is
Huh?
mentioned in the NIT,
Okay,
my lord,
it's
this
mentioned.
notification office. my
Where,
lord.
where?
Yes, my lord. Page 37.
37, yes. What does it say?
Yes, my lord. Here mentioned the henceforth all the administrative departments and so, my lord, is procurement all goods, services, works
Okay, now let me ask you a question.
Yes, my lord.
You submitted your tender, even though, and it was considered. It was considered or not?
Rejected because court fee clause was not there.
Okay, because of court fee
Yes,
clause, not
yes.
that. But otherwise, no prejudice is caused to you because you participated in the tender.
Participated,
process.
And my lord, there was no publication of the tender. Earlier also, I challenged the, already I have, my lord, earlier NITs, NIT, my lord, 2812. That is what has been challenged, second challenge was there, my lord. That was also not properly, my lord, there was no publication among the public. In
There was
office-
no publication among the
Yes,
public.
Yes, my lord.
What do you mean?
Because, my lord, this NIT, I could not be able to hear anything about the second NIT. So that's why I have.
Yes. He says that his tender was
There is miscommunication between the council and the petitioner himself, because my lord, court fee was not a ground to reject him. In fact, technically, my lord, he was found fit.
okay.
There was a tie,
Okay.
there was a tie, and there's a clause, my lord, when there's a tie between two persons, my lord, we'll check the 3 years turnover, my lord. In which he turns to out to be unsuccessful.
Oh.
And work order has been issued way back in 11/1/24. Now work has proceeded to 80%.
What is this? What is this item?
This is for my lord nursery, establishment of a nursery.
Nursery. Oh.
Nursery.
Yes, you have not been disqualified.
It doesn't.
Unfortunately,
I have the
you lost the race. You are allowed to run, but you came second.
No, no.
Where is the document showing that you have been disqualified?
I have not received it.
You don't have. Everything is
also.
everything is through your client's mouth. Whatever he says, you believe it to be the gospel truth.
I have yellow mark, my lord.
Yes. What is his name?
His name is Dhireshwar Nath.
Okay. Offered price is
At par, my lord. He,
Very good.
he,
he's not rejected.
he's not rejected, but there was a tie.
He okay. There's a tie to every okay. But L1 is Ranjit Kumar and L2 is Firoz Ahmed.
Fine.
He comes after that.
Yes, fine. Because annual turnover has to be looked into. My other documents.
From where? From where do you say annual turnover has to be?
That is also my.
My lords, no, my lord. My lord, the other document, my lords. The tender clause, my lords, of 10.9.
10.9.
10.9. In
In
fact,
case
lordship,
of equal
lordship will find
score
it.
of two bidders, the bidder having a higher average annual turnover in last year will get preferred. Okay.
In the other page, my lord, there's a comparison. Who has worked?
Dineshwar Nath has got 1 crore 86. This other person has got 11 crores.
That is the person, my lord, that is respondent, who has been allotted the votes.
But on what basis they have, that is also one of the ground, right?
This is my lord, 10,
One hundred-
10.9, page 23.
Okay, very,
11 crore, he has not completed.
very
There is no
simple,
experience.
very simple. If you want for satisfaction of your client,
Yes.
we'll give them 6 weeks time to file the affidavit
Yes, yes, madam.
and that's all. No
Yes.
stay.
My prayer is only to, my lord, in the public interest, not to obtain that job, my lord, this work order. Because, my lord, it has to be properly public. There must be proper publication among the public, my lord, all NIT, my lord. On online basis, it has to be.
Mr. Counsel, once you have taken part,
Yes, my lord.
you cannot say that. How can you say in the first place that any prejudice has been caused to you? What prejudice has been caused to you? Just because it was not published online. You
I-
participated,
Participated,
then
but generally it has to be
what
followed.
mean generally? That you go in a PIL and you say that from now on everything should be done online.
Any-
Right now, no right of yours has been affected. Where is your right? Which right of yours has been affected? This is a writ court. This is not a PIL.
Yeah.
Then, and then now they have said this. Why should I in fact entertain your
Yes,
writ petition? I'll dismiss it straight away.
in fact, my lord,
Okay.
paragraph 10.
I've got the thing. If you find that what I'm writing in my order is wrong, you can go to division bench and say this is wrong.
No, let it, they file affidavit.
No.
And
He
even,
has
Yes, my lord.
stated that.
my lord,
I have
even
not
in paragraph
seen that.
10, my lord will have a look. The petitioner is not himself clear what is asking for. Paragraph 12, which starts as 11, paragraph, page 11. It continues to page 12. Lordship will see the first lines of the prayer, my lord. Resultantly, the said contractor, although he may be deleted from the column, what is writing?
Fishing around, that's all.
Anyway, these are only just meetings.
Although he may be deleted from the column of response, if he is not a mallet, it is said work in question. What is going
No,
on?
no, I have an
Yeah,
X.
no, your prayer is only for quashing the
Yes,
NIT.
yes, that
That's
is
all.
only, that much.
So there is no ground to quash. Right, heard Mr. H. Das.
Let him file affidavit, my lord, for,
Mr. Counsel, I've heard you. Let me do my part.
yes, yes.
You have done your part. Okay. Heard Mr. H. Das, learned counsel for the petition. And Mr. D. Gogoi, learned counsel for the forest department. Then that whatever he has said, huh? Not pressed. Huh? Where is this 9/12/23? No, NIT?
It's at page number, my lords. 39. In
The
fact,
pe-
that also has been cancelled due to, my lord, there is no competition, my lord. The people didn't take part, my lord. So we are cancelling the tender also.
Acha, this one, no, he's,
2011 and 2012 also been cancelled, my lord. This is the paper.
more than the one he has, this election has been done in respect of which?
9/12. 9/12.
That's what I'm saying.
9/12 has been completed, my lord.
That's what I want, the 9/12, not 39. I
Oh,
want
my lord,
9/12.
then it's at page number
36.
Okay, right,
9/12 is it 18, page 18.
page 18. Page 36 also,
Yes, 36.
right. The petitioner's case in brief is that he had taken part in the short notice inviting tender, bracket, hereinafter referred to as, not bracket 3, comma, hereinafter referred to as the NIT, dated 9/12/2023. Short notice inviting data, tender dated 9/12/2023, hereinafter referred to as the NIT. Huh? For erection of boundary fencing. No, don't say that, pertaining to GLPSF -3. Comma, that is erection of boundary fencing around 25 hectare AR plantation at Bandar Matha, comma, Lakhipur, at an estimated cost of rupees 28,59,850. Next paragraph. The petitioner participated in the NIT by submitting his bid and being unsuccessful in the tender process, has put to challenge the NIT on 3 grounds. Firstly, on the ground that as the estimated cost was above 20 lakhs, comma, publication of the NIT should have been done through
E-tender.
e-tender and not by way of advertisement in a newspaper. In terms of the OM dated 10/6/23 issued by the Commissioner Secretary to the Government of Assam, comma, Finance Department. The second clause, the second ground of challenge to the NIT is that no court fee had been mentioned, the court fee payable had not been mentioned in the NIT, comma, though the same. No, was not mentioned in the tender form.
Tender.
In the tender form, comma, though it was mentioned in the NIT. Full stop. Thirdly, the NIT was signed by the DFO and it was not countersigned by the conservator of forest. Full stop. Next paragraph. the petitioner's counsel submits that the petitioner's bid was rejected on the ground that he did not submit court fee. Yet he submits that in view of the reasons stated above, the NIT dated 9/12/2023 should be set aside. And a fresh NIT should be published through e-tender process. Next paragraph. Mr. D. Gogoi, learned counsel for the state respondents, on the other hand, submit that the petitioner's tender was considered by the respondents and it was not disqualified. As there were 4 tenderers
My lord, 4 tenders.
who had given the,
Quoted same price.
had quoted the same rate. 4 tenderers out of 11 tenderers who had quoted the same rate. And whose tenders were valid, comma. The selection of the successful tenderer was made on the basis of clause 10.9 of what? What is this?
Bidding document, my lord.
10.9 of the bidding document, which provided that in case of 2 bidders having equal score, comma, the bidder having the higher average annual turnover for the last 3 years would get preference. Full stop. He submits that as one Ranjit Kumar Das had a higher turnover for the last 3 years amounting to rupees 11,07,16,750, as compared to the petitioner's annual turnover for the last 3 years amounting to rupees 1,86,10,576. The bid of Ranjit Kumar Das was accepted. And he was awarded the work order. He was awarded the work. 2024. So Mr. D. Gogoi submits that 80% of the work has already been completed by that Ranjit Kumar Das. Is he a party here?
Yes, my lord. That's
That is the respondent number 5 in the present petition. Next para. On a query put to the petitioner's counsel as to the basis for which the petitioner has taken a stand that the NIT should be countersigned by the conservator of forest, comma, the petitioner's counsel submits that he does not have the set basis with him at the moment. As can be seen from the submission made by the counsel for the state respondents, the petitioner's bid document had not been disqualified or rejected by the authorities. The comparative statement of bids which Mr. D. Gogoi has submitted shows that out of 11 bidders, the bids of 5 persons had been rejected. The bid of the petitioner herein was not rejected or disqualified. Next paragraph. The above being said, comma. Once the petitioner has participated in the bid process in terms of the NIT dated 9/12/2023. No prejudice can be said to have been caused to the petitioner just because the NIT was not published in the, by way of any tender process.
No, my lord, it was e-tendered also. But
E-tendered?
Yes, my paragraph 6. His contents is different. The website has been different, madam.
Oh, okay.
Paragraph 6.
What have I said? Was not published by way of e-tender process in www.assamtender.gov.in. The NIT had been published in
AssamForestOnline.in.
in www.assamforestonline.in. Next para. The above being said, comma. The division bench of this court in the case of Dash versus Dash has held that when a person participates in a tender process and is successful, comma, he cannot turn around and challenge a clause in the tender notice. That is Justice Sandeep Mehta and the judgment is there. In view of the reasons stated above, comma. This court does not find any merit in the writ petition. The writ petition is accordingly dismissed.
So far, this WP gender is concerned, that clause is not mentioned in the this NIT.
It doesn't matter. You took part in the selection process, Mr.
Yes.
Nazir. Yes.
That is.
I can understand if you did not take part,
Yes,
but you took part. What,
Yes,
what
I
role is-
participated.
That documents I produced may be marked as annexures.
Just say the comparative statements and the other the comparative statement of the bidders and the other connected documents are made a part of a record and marked as Annexure X collectively.
But that, my lord, that copy may be furnished by my lord.
I'll give you. That doesn't need a judicial.
How does it make a
Yes.
difference? We have participated.
Yes.
Your entire case is gone.
Always.
Obviously.
16.
Similar matter, subsidy in orthodox theology may issue notice.
Which one?
16, my lord.
What is this?
Regarding non-issue of subsidy, my lord.
Subsidy in orthodox theology.
In school?
Orthodox theology.
My lord.
Tea garden. Okay, right. Heard, Mr.
RS Mr.
R.S. Mishra, learned counsel for the, what is the validity of the scheme?
It is from 29/12/17 till 31/3/20.
29/12/17 to
31/3/20.
31/3/20. We're coming now. Why?
Applicant has been made, my lord, they are not considering it.
Okay,
We
right.
have already applied also.
Okay, Mr.
RS Mr.
R.S. Mishra, learned counsel for the petitioner submits that the petitioner had made an application for subsidy in terms of the scheme, which was valid from 29/12/17 to 31/3/2020. However, the petitioner's application has not been processed till date.
Madam.
Issue notice returnable in 4 weeks. Mr. R. Gogoi, K. Gogoi,
All the respondents.
appears for all the respondents. This is the matter after 4 weeks.
Obliged.
My lord, there was an advertisement for granting license of retail outlet dealership under ICS, IOC, my lord. That may lordship may kindly see page 21.
Retail outlet where? Which place?
At Guru House and Shobha Sugati. So,
Where?
page 21
Ah,
is the advertisement and our name. Here was application appointment of retail outlet dealership in the state of Assam. So accordingly, my lord, we offered our application for the same. And in the long run, my lord, our case was considered and we were selected. Lordship may kindly send up page 27. There were 5 applicants.
yes,
And my name is Sri, my lord, Sri. Shahidul Islam, he is the not personal capacity, but he is
Selected,
selected. Now, lordship, there was an letter of the IOCL that lordship may kindly see page 39. Page 39, your lordship would see 39 bottom, you are requested to remit online so and so towards rupees 50,000 towards initial security deposit and upload the set of the self-attested documents as specified below by 18/12/2023. So we were given time up to 18/12/2023. Now, we accordingly within the time we deposited every document, also paid money. Now, lordship may kindly see impugn of first order, page 40. Yes, page 40. It of 40 portion, page 41, my lord.
Ah.
Sorry, my lord, page 42. Page 42.
yes.
Bottom kindly see, however, we have not received any response and or required documents from you within the stipulated time. Now, lordship would say, they have said that by 18/12/23, I have submitted every document, now they are saying, and then lordship would say, within the stipulated time, register list date uploaded is of date 16/12/23. Which is after the date of application submission, list should be registered before the date of application. Now, lordship, one thing, they have said that our list date, which was registered, it is dated 16/12/23. And that was submitted on 18/12/23. Now, we cannot submit this document because why not? For getting a deed registered, 30 to 40 days time is required. Because nowadays, my lord, they will submit an application on online that will be processed in the DC office, District Commissioner's office. District Commissioner will pass appropriate order asking the register to register the document. And thereafter only the sub-register or senior sub-register get it registered. And thereafter only we can submit to them. So they wanted something which is beyond our capacity.
They asked you to submit by 18/12.
Yes, 18/12 first.
So then your registered list date is of 16/12.
16/12, and
So
it
there
was
is time.
submitted before the authority, IRCL authority on 18.
Okay.
So in our view, my lord, we have submitted everything in time. But before application or at the time of application, we could not do because there are certain restrictions in getting the SLD registered. So we got the land from 2 persons and that is registered. After due formalities, 30 to 40 days time is required, and thereafter we have submitted. So for that reason, my lord, they also said one thing, my lord, kindly again see page 43, second para. In view of above, we regret to inform you that your candidature has been found ineligible. In case you have any grievance against the rejection of your candidature, as mentioned above, you may make your representation by 19/2/2024. So that option was given to us. Accordingly, my lord, we submitted application that lordship may kindly see page 51.
Yes.
51 is our representation. We said, and our clear case was that, my lord, kindly see page 51, third para. But it is a matter of regret that your letter dated 9/2/2024, you have entirely stated that due to submission of application without the registered release date in time, our application has been rejected. In this regard, I beg to state that for registering a lease deed, the prior permission of the district commission is required. The petitioner, after doing all the formalities, registered the lease document on 16/12/2023 and submitted the same on 18/12/23. As at first for the registration of document, the application is filed before the district register online. And as per procedure, the district register commissioner allows the application and thereafter issue permission letter to the sub-register for registration. For all this 30 to 40 days time is necessary. So, my lord, these are the formalities which are beyond our capacity. So accordingly, we have done, but unfortunately, my lord, they by the improved order, page 54 now, lordship kindly says. They have rejected our petition. Now, operative portion may be seen page 55.
Just a minute, at page 54, please let us see.
54 is the order, improved order.
Let us read the entire thing. Referring the letter says, so refer the application. Please refer to clause 4. The land that can be offered by an applicant is categorized. Having suitable piece of land in the the land should be available with the applicant as on the date of application. So on the date of the application, you did not have the land.
No, on that day we had land. We had land, but that should have been registered. And the registration has been done. That registration, lordship may kindly see page 34, madam. Because we have to, in the name of society, there is no land. Now we have to take land on rent. So that was taken, everything was done in time, but the time factor is because of these formalities. Page 34 is the registered document. So it is registered on 16/12 and it is submitted on 18/12. And by their letter 8/2023, they said that here every document should reach by 18/12. Now all of a sudden they change their stand and the society is suffering well. If the retail license.
We'll have to go through, look at page 54. You have to read, you cannot skip. Let us read the entire thing. Let's see if you fulfill page 54. Let us see. Refer your letter. Refer brochure. Now please refer to clause 4. Land that can be offered by an applicant is categorized in the following 3 categories. Applicants having suitable piece of land in the advised location area either by way of ownership / long-term lease for a period of 19 years.
Right. We have taken up for 20 years.
On one.
We have taken the land of land that is for 20 years. Registered that is also registered. So, my lord, here one thing only this, my lord, they are demanding
Just a
something.
minute. Quote, for society, registered lease deed uploaded is of date, which is after the date of application submitted. Yes.
So, my lord, we admit there is some deficiencies in our application because that was beyond our capacity. Now it is settled position that nobody can be asked to do impossible. Earlier, my lord, any day the land could have been registered, said it could have been made. But nowadays there are so many formalities which we have to overcome before getting it registered. So due to only not submitting at appropriate time, we were selected, we have paid rupees 54,000 as required. So, and this is a society matter, not an individual. The public interest is involved there. So our submission is this, my lord, let the notice go and till the matter is heard and decided by your lordship, the said retail dealership license may not be granted to anyone.
You do not fulfill the tender clauses, it appears. You see, if you do not fulfill the tender clauses, it's very difficult, supposing we allow your prayer. Then tomorrow everyone will file an application, will file this kind of tender.
I have some citation of the Honorable Supreme Court also.
Yes, yes, please.
That because lordship is aware, getting only one defect they have found that we did not submit the register salary that with the application. So here Honorable Supreme Court, my lord, in the civil appeal number 5728 of 2022-5, in Gyanchand case, it is said no person can be asked to produce such a document which is beyond his capacity. So this is one in time, that is para 12. Another such citation, my lord, that is live law. Here, no person can be asked to do something which is impossible to do so. So another citation is I have also there.
But I'm quite sure there are other tenderers who have done so.
The other tender are not selected, my lord. Only I was selected.
So they will now be selected. If
That-
supposing, you see, you have to see whether for the other tenderers, was it possible to submit documents?
At present, we cannot say what is the position, but thing is this, my lord. After all, I was, this Burwaja Samaya Samiti was selected. Now, due to one deficiency that nobody perhaps can do because their candidature was not considered.
Okay, give me a citation. Just underline the portion that you
So
are.
it is thick one.
Just underline the portion that you have underlined.
In Mohammad Ghazi's case also, that is the reported case 2004 SCC 342 para 7, that nobody can be asked to do impossible. So the registration is beyond our capacity.
What happens if some of them can do the impossible and some cannot do?
Here, my lord, as appears from the document, nobody could do because I am selected. That means others are not selected. That means I have better documents than them. It is presumption. Now, my learned friend may say in a better manner how, because I was selected. That means I have done good. I have done as per law. Only one deficiency that is beyond my capacity. That lordship may kindly also note down this 2004 SCC 342 para 7.
Good. Well, okay, 2000. Have you given a list of books?
Only these three judgments, my lord.
But it is your
I have
duty.
given copies of 2 and last only 1.
It's your duty to give. You are a senior counsel now. You said 2000?
2004, 2000 volume 4.
2000 volume 4.
Yes, SCC 342 para 7. My lord, I am not seeking so much, my lord. I am only seeking that notice go. And till then, my lord.
Let me hear the other side.
Yes.
The petitioner has not annexed the.
My lord, I am been told by court over 13 immediately. My junior will be here. So you kindly explain. Oh, sorry. Now I can speak at 2 p.m.
The advertisement has not been annexed.
Not really.
Has not been annexed.
But it appears from this, page 54.
Yes, my lord, the detailed order has been passed.
Huh?
Detailed order has been passed. Earlier, my lord, after he was selected, then a letter was given to him asking for certain documents. What are those documents? This has been specified in this order at page clause 5. Your lordship will. Page 54, the Indian order and rating. Clause 5, down below. Now, please note that in your application dated 13/10/2023, you have declared the land offered by you as falling under Group 1. That is important because Group 1 will be considered first. However, post-selection, through online computerized lucky draw, you have uploaded a registered lease deed executed on 16/12/2023 in the interest of natural justice, and email dated 18/1/2024 was sent to you asking for the following. Your lordship will see what was asked for. For society, applicable affidavit, then number 2, registered lease deed uploaded is of 16/12/2023, which is after the date of application submitted. Lease should be registered before the date of application submission. If there is any such registered lease deed executed before the date of application submission, please upload the same. So the IOC gave him an opportunity that if you have got any other lease deed prior to the last date, you file. Now, my lord, petitioner's case is that it was not possible to get it registered in a short period of time. That is his case. But in your lordship, will kindly come to page 32. Their own document. This is a resolution passed by the society. They are a corporate society.
32, yes.
Page 32. Translated copy of a relevant portion of the resolution. Today on 27/9/2023, under the chairmanship of our committee so, a meeting was conducted where the following resolutions were adopted. Resolution number 3. In today's meeting, a resolution is taken that as per resolution number 2, if our Samabay Committee is selected, then land will be taken on lease. Therefore, they were waiting for the selection. If I am selected, I will apply. That's a very case file. He was not eligible on the last day. He was given an opportunity. If you have got any other land,
So this proves that they did not have any land.
they didn't. And it was not something impossible that my friend is saying.
They were, so the land was subject to them being selected.
Then only they will take on lease. But even then, Mallar also given opportunity. If you have got any other land, deed executed earlier, please provide it.
Can't they be considered?
My lord, we are bound by the brochures. That is for compulsory for mandatory for all the oil companies.
For everyone.
We cannot divert from that.
My lord, as a matter of reply, my lord.
Huh?
I will give some reply to another friend. First thing, the resolution, my lord, actually, there, the society one, what they have taken, adopted, I cannot go beyond that. So that is theirs. Second thing, my lord, land should be, but it is not a must that land should be in the name of society. Any land may be taken on mortgage or lease, and that we have done.
But
And lordship, main thing is here, page 39. Now they are saying so many things, but page 39 kindly see for a moment. Last parameter. If you are requested to remit one line so towards initial security deposit and upload the set of self-attested documents as specified below by 18/12/23. To pay ISD and upload documents, this is very important, documents, click here or so and so that your application for award of retail outlet dealership at the above location can be processed further. Now date is given here 18/12/23. Now 18/12/23 we have submitted the registered deed.
It was registered on 16th and it has been submitted on 18th. So on the date of application, we could not do. But even then, my lord, we were selected. We were selected. That means at preliminary condition we fulfill. Otherwise, how out of 5 or 6
You
candidates?
see, that is only to, you see, that is only for verification purposes.
That is only on the basis of their
You see,
application.
because if you come
Whatever
to
they have
page
declared.
54,
Or
page 54, clause 4,
whatever,
specifically states, the land should be available with the applicant as on the date of application.
That might not, I have said that because of this problem, and the affidavit was also also shown in my note. That lordship may kindly.
So it is not impossible to get the lease deed. But the problem is that you waited for being selected.
No, lease deed may be made, but registered lease deed, that is the problem.
Whatever it be.
But before registration, when the time is required. And kindly see page 28. Here the person who has given us.
You see, it's like this.
Page 20.
Page 28. Okay.
This is the affidavit sworn in by the person whose land we have taken, because at that time, they have sworn an affidavit, kindly see, page 29. I, Mohammed Ali, as so-and-so, and Eliza Begum, so-and-so, we are the joint partners of periodic partner number so-and-so, covered by tag number so-and-so, so-and-so, and it is dated by 5/10/23. 5/10/23.
It only says that they agree to lease out. It has
Yes.
not been leased out.
Leased out for that
It's
registration.
like saying that I'm going to sell you the land. Doesn't mean that that land has been sold to you.
No, that lordship may believe, because thereafter they have executed
I
registered.
agree, but then the tender clause is such
So chain of circumstances are tallying with each other.
difficult, Mr. Man. Unfortunately, difficult, because another thing is your resolution at page 32 also. You have shot yourself in the foot for that. Okay, right. Right, Mr. M.U. Mahmood. Learned counsel for the petition. And Mr. M.K. Chowdhury, learned senior counsel for the All India
all the
Limited.
respondents.
All that's fine. Proceed. The petitioner has paid for setting aside the impugned letter dated 9/2/2024. It's not 9, it will be 19/2, I think. Huh?
One is 9/2, another is 19/2.
Acha, 9/2 is that page.
9/2. Yes. Page 39. 9/2, page 39. And 19/2, page 54.
Why should you challenge this?
Because
Why should you challenge page 39? And this page 39 is 8/12/23. This is not 9, this is not 9,
9.
9, this is not 9. 9/2 is page 42. Has paid for setting aside the letter dated 9/2/2024 and 19/2/2024 issued by the respondent. Whereby the petitioner's candidature for being awarded for being appointed as retail outlet dealer for the location. our dealer under the IOC, Indian Oil Corporation Limited. Bracket IOC. For the location within inverted commas, within 3 kms from Batabari Chowk towards Rauta Charyali on NH 15, inverted commas two, Darang district. Has been found ineligible. And appeal, and the subsequent appeal dismissed. Next part. The petitioner's counsel submits that pursuant to the where is the NIT is not here?
It has not been annexed.
Pursuant to a tender notice for granting retail outlet dealership license within 3 km from Batabari Chowk towards Rauta Charyali on National Highway 15, Darang district. The petitioner submitted his application for the same on 13/10/2023. Pusta. The petitioner was thereafter informed that he had been selected for the said dealership. No, for said dealership. And was accordingly requested to remit rupees 50,000 online as initial security deposit and to upload the self-attested documents as specified in the letter dated 8/12/23 by 18/12/23. The petitioner thereafter remitted the 50,000 and uploaded the self-attested documents as required in the letter dated 8/12/23. Full stop. However, the respondents by the impugned letter dated 9/2/24 informed the petitioner that the registered lease deed uploaded by the petitioner was dated 16/12/2023, which was after the date of submission of the application for the dealership. The letter further stated that, the letter dated 9/2/2024 further stated that as the lease should have been registered before the date of the submission of the application, the petitioner's land did not fall under Group 1 on the date of submission of the application. In fact, the applicant did not have any right over the land covered by the registered lease deed which had been uploaded. As such, the petitioner's candidature was found to be ineligible. The petitioner was also informed that he could make a representation by 19/2/2024 by the impugned letter dated 9/2/2024. Next para. The petitioner thereafter submitted a representation to the respondents, praying for being awarded to the respondents in terms of the impugned letter dated 9/2/2020 and requested that the dealership should be awarded to the petitioner. The late submission of the lease deed was also attempted to be explained by the petitioner by stating that for registering a lease deed, prior permission of the deputy/district commissioner was required. And as such, they could not submit the same prior to, no, they could not submit the same at the time of submitting their application. Let's start. The representation of the petitioner made on 19/2/2024 was, however, rejected by the respondents by letter dated 19/2/2024. Was rejected on the same day, by the respondents on 19/2/2024. Next part. The petitioner's counsel submits that though the petitioners were owners of the land, they could make the registered sale deed only after a lapse of 40 to 45 days, as the procedure involved taking the approval of the deputy/district commissioner. He submits that it was impossible for the petitioner to submit lease deed as required under the NIT during the time period available. In support of his submission, the learned counsel has relied upon the judgment of the Supreme Court in the case of State of Rajasthan and others versus Anil Kumar, Sunil Kumar, huh? No, sorry. In the case of Mohammed Ghazi versus State of MP, 2004 SCC 340. Gyani Chand versus State of AP, 2004 SCC. Correct, thank you. 342. Thank you. What is it? Acha, no. Gyani Chand versus State of AP, civil appeal number 5728 of 2005. And in the case of MS Om Guru Sai Construction Company versus MS DN Reddy and others. 2023 live law bracket SC 694. The petitioner's counsel submits that in view of the above, the respondent should be directed to issue the retail outlet dealership license to the petition. After setting aside the impugned orders dated 9/2/24 and 19/2/24. Mr. M.K. Chaudhary, the learned counsel for the IOCL, for the respondent, submits that the petitioner was to be the owner of the land on which the retail outlet was to be established, or have a long-term lease for a minimum period of 19 years, 11 months. At the time of submission of the application pursuant to the NIT issued by the respondent. the petitioner clearly did not have the same as is reflected in the resolution number 3 of the Board of Directors meeting of the petitioner held on 27/9/23. He submits that as the petitioner did not have the mandatory land documents at the time of submission of his application, the writ petition has to be dismissed. I have heard the learned counsel for the parties. The facts of the case, no, the submissions made by the counsel for the parties. No, before that, I've heard the learned counsel for the party. Resolution number 3 of the Board of Directors meeting of the petitioner society is reproduced here and held on 27/9/23. Is reproduced here and below as follows. Page 32. The above resolution number 3 and the submissions made by the counsel for the party make it clear that the petitioner did not have ownership of the land in question in which the outlet, dealership outlet was to be established. At the time of, did not have ownership of the land or a lease deed for 19 years, 11 months. At the time, the application for dealership outlet license had been applied for by the petition. Next paragraph. The petitioner has not annexed herewith the NIT on the basis of which she had made the application. So, however, the rejection of the petitioner's appeal / representation via the impugned letter dated 19/2/2024 has clarified the fact that under clause 4 bracket Roman 6 small bracket small a, comma, the tenderers were to have, the bidders were to have the land on which the retail outlet dealership was to be established at the time of submission of their application for the same in terms of the NIT. Yes. The contents of the letter dated 19/2/2024 issued by the IOC Limited is reproduced herein. Is produced below, produced here and below as well. Take it from page 18 to page 54. In next paragraph. In view of the petitioner not having the required mandatory documents in terms of the NIT, this court does not find any infirmity with the decision of the respondent authorities in coming to a decision that the petitioner was ineligible to be selected for the Senate. Retail outlet dealership under the IOC limited. Consequently, this court is of the view that the case has, the petitioner has not made out a case for this court to use its discretion in the present case. The writ petition is accordingly dismissed.
And you oblige. These judgments we have to mention, huh? Later on, you just remind me, I'll just mention these judgments.
No, it's not. Regarding my lord, payment of balance outstanding bill, man. Lordship will find pay from page 18 at the work orders. And admission is lordship page 30. They have admitted that part payment has been made and liability balance amount spending.
Actually, here we need to obtain instructions. Actually, kindly, notice may be issued. Actually, we need to verify whether it's an FMP scheme or not.
Okay.
I'm issue notice, man. Scheme is also there, my lord.
Heard, Mr.
Yes, no.
S. Nath,
Yes.
learned counsel for the petitioner, who submits the petitioner's unpaid contractual bills should be paid for doing contract works for protection of the land eroded by the river at Karichera, bracket Daryaghat area, on the right bank of the river Katakhel and the Hailakandi Water Resources Division. Issue notice returnable in 4 weeks, Miss,
DG,
accept notice on behalf of
all the
all the
respondents.
respondents. Will come out of the.
Right.
All right.
May I please allow, sir? The matter related to settlement of market, my lord. Initially, my lord, the NIT was issued by the Poop Mughal Anchalik Panchayat, my lord.
What was issued?
NIT,
NIT dated
dated, my lord, issued by Poop Mughal
10/4/23.
3, my lord.
Ah,
Poop Mughal Anchalik Panchayat, my lord. Thereafter, pursuant to NIT, my lord, 14 tenderers submitted tender. 14 tenderers. Submitted
14 tender.
14 submitted tender, my lord. The first tender highest bidder withdrawn his tender, my lord. Thereafter, my lord, the Jila Parishad by order dated 30
Highest tenderer withdrew.
withdrawn.
Ah,
Thereafter, my lord, by order dated 31/7/2023, Jila Parishad settled the market with the second highest bidder at the bid below is so and so. Thereafter, my lord, remaining 12 out of 12 tenderers, 11 withdrawn. Only one left, my lord.
so you're the only one left.
No, I am not on that. My lord, thereafter, my lord, when my lord withdrawn, thereafter, my lord, after few days, my lord, by application dated 7/9/2023, the settlement holder surrendered his settlement, that he is not in a position to continue his settlement.
Okay.
That was 7/9/2023 to the Jila Parishad. Jila Parishad will accept it. And therefore, Jila Parishad started to run it by Jila Parishad himself, my lord, themselves. There was a clause 9 in the NIT that if any tender value is not suitable for settlement, then Jila Parishad can issue retender notice. So I am being intending tenderer. Further, I applied before, as well as others, my lord, before the Jila Parishad to issue retender notice. Jila Parishad assured us that we will issue it positive, but they delayed it. Then we came to the High Court, my lord, seeking direction to the Jila Parishad to issue retender notice, as they are now running it by themselves. Thereafter, court issued no show cause notice in this case, my lord, matter is pending. Thereafter, my very surprisingly, my lord, on 1/2/2024, Jila Parishad again settled second settlement to that person, settlement holder who already refused to continue, who already surrendered.
The second highest bidder.
No, my lord. Or second high bidder, yes, second high bidder. So once he is resigned or once he is surrendered, that has been accepted. At Jila Parishad, that period ran it,
then thereafter, my lord, how Zilla Parishad can settle it again to you? That is
No, but earlier, initially there were 4 tenderers, 14.
14.
The highest tenderer
You
withdrew.
don't, my lord.
Then the second highest tenderer was given.
Oh, yes.
So if just a minute. So if the highest tenderer withdraw, there are 13 left.
13 left.
If there are 30, then the highest tenderer, second highest was given.
Yes,
If second highest has given, there are 12 left.
yes, 12 left.
12 left.
12 left.
Then 11
11
has,
withdrawn.
11 so there is one left.
One left.
So if the second highest has withdrawn thereafter,
Yeah.
then it has to be given to that.
But there is a clause, if tender value is not suitable for settlement, that was much lesser.
Who is that remaining tenderer? That is not you.
That is not me. He is not before this honorable court. my lord.
He has not made him a party also.
Yes, I have not also made it. So, my lord,
Will his right be affected?
he did not come to the court. He also not before this honorable court.
Huh?
He did not come to the court, my lord. But I have come
He-
before this
he-
honorable only to get the benefit as per clause 9. There is specific clause in the NIT. If settlement tender value is not suitable for settlement, then Zilla Parishad can issue retender.
So since he has withdrawn, that second highest also has withdrawn.
Withdrawn.
So now according to you, either they run it themselves
Or
they
issue retender.
and the earlier writ petition was challenging what?
Seeking direction to issue retender notice by Zilla Parishad. That is pending. That is also why myself.
Why have you filed this two
Hereby I am selling the subsequent settlement order.
again?
Next settlement order.
Right.
Second settlement order.
Second settlement order dated
1/2/2024. 1st February.
1/2/24 and the earlier settlement order
Earlier settlement was, my lord, on 31/7/2023.
31/7/23
Yes, sir.
to the same person.
Same
And
person.
when did he withdraw?
Withdrawn, my lord, on 7/9/2023.
Yes, okay, right. Heard, Mr.
B. Rama.
Learned counsel for the petitioner who submits that in pursuant to the tender notice dated 10/4/23 issued 10/4/23 for settlement of the Tangni Weekly Open Market for the period from 2023 to 2024, 14 tenderers submitted their bids. The highest bidder withdrew his tender. And out of the remaining 13 bidders, the second highest was selected to run the market
So, settle it.
wide order, to run the market wide order dated 13/7/2023,
31.
13/1/2023. Thereafter, the 31/30,
No, 31.
31 what?
31,
7.
7.
Thereafter, 11 out of the remaining 12
12.
bidders also withdrew from the tender. Next para. The second highest bidder refused to run the market thereafter with effect from 7/9/2023. Which necessitated the Anchalik Panchayat to run the market.
Then
Full
Zilla Parishad started to run the market. Zilla Parishad-
Necessitated the Zilla Parishad to run the market. However, the Zilla Parishad has again settled the market with the second highest bidder on 1/2/2024, even though the second highest bidder had withdrawn with effect from 7/9/2023. Next para. The petitioner's prayer is that a retender for the market should be made and the settlement of the market with the respondent number,
Respondent 7.
respondent number 7, bracket second highest bidder, right, so should be set aside. He also submits that the petitioner has submitted an earlier writ petition dated 7239/2023, which is still pending before this. This matter along with WPC 7239 of 2024. On after 2 weeks. After 2 weeks. Before there's an issue notice returnable in 3 weeks actually. 3 weeks. Petitioner takes steps for service of notice upon the respondent number 7. Or what? Wait, who you accept notice on behalf of who, madam?
Lordship, I am appearing for respondent number 1, 4, and 6.
Or one, Miss so accept
And
notice.
Bora.
And Bora accept notice on behalf of respondents number 1, 4, and 6. Who appears for DC? Mr. K. Gogoi appears for respondent number 2. What about Zila Parishad?
3 years.
Notice.
Represented by its president.
3, 5, and
3, 5, and 7.
petitioner takes steps for service of notice upon the respondents number 3, 5, and 7 by registered post with AD within
As well as Dasti.
within today.
No, possible.
Within
As well as
within
Dasti
3 days. Full stop. In addition to the above, the petitioner shall take steps for service of notice upon the respondents number 3, 5, and 7 by way of dusty service and file affidavit of service thereof. This is the matter. After 3 weeks.
Interim order will be subject to the result of it.
One interim order.
Maybe
One interim order can be used.
impugn order, my lord.
Huh?
Impugn order will be subject to result of petition.
The impugned order will be subject,
to the
okay, the impugned order will be subject to the
result of
outcome of the writ petition.
my lord. I love.
Yes,
May I please? My lord, here matter is that, my lord, not non-allotment of vita room
Huh?
to the petitioners. Non-allotment of vitas,
what,
vita, my lord, room
room,
in the market area.
okay,
Actually, my lord, what happened there, my lord, the petitioners are running their business in the Lonka regulated vegetable market from last 10 to 20 years. And just 2 years before, my lord, municipal board promised the petitioner that they will destroy the sheds. And in that place, my lord, they will build a concrete structure. And now, my lord, market is almost over. And recently, my lord, the Lonka Municipal Board has issued a notice, if lordship may kindly come to page 33.
yes,
My lord, now they are trying to allot the rooms to some other persons by way of a secret deal, man.
by way of a secret,
Deal, my lord.
deal,
Yes, my lord. From every other businessman, they have taken rupees 5 lakhs each. For that, my lord, I have made a representation also to the deputy commissioner. If lordship may kindly come to page 41, annexure 4, my lord.
page 41, yes,
The General Secretary, Lonka Wholesale Vegetable Vendors Association. Alleging all that, my lord, everything.
look, these are disputed questions of fact. These are properties, this is not your property. No. Just because you have been running some shops, there have been some stall there, have been selling your wares, doesn't mean that you are the owner of the land.
No, that's not that.
What do you want?
From last 10 to 20 years, my lord, we have.
We
running
do
our
not know,
business.
we do not know, that is your stand.
We just got the opportunity first, my lord,
You want the opportunity to do what?
for allotment of the shop, my lord, first.
Then you'll have to follow the procedure.
But we are not following any procedure, my lord. It is the typical.
You're willing to pay 5 lakhs also.
Not possible. We are very poor vegetable vendors.
We'll issue notice, that's all, nothing else. Not now.
My lord, and only to stay the operation of the.
No, nothing doing. Sorry. You can go to the division bench, ask them. You can ask the division bench, not here.
Then Lordship may issue notice and, my lord, only or Lordship may direct the deputy commissioner to inquire the entire matter, my lord.
No, let us hear the other side first. No. Heard, Mr.
Yes, Chaudhary.
A. Chanda.
Yes, Chaudhary.
S.
Yes, Chaudhary.
S. Chaudhary, learned counsel for the petitioner. Petitioners who submits that the petitioners had been running their business by selling raw vegetables in the Lanka wholesale raw vegetable market under tin sheds. However, the Lanka Municipal Board has now started constructing concrete rooms and collecting money from businessmen for allotment of the said concrete structures. The petitioners, on the other hand, do not have the money to reserve the concrete structures, such room. And he further submits that there is no guidelines or mechanism made out by the respondent authority for distributing / allotting the concrete rooms / structure to persons like the petitioner. Issue notice returnable in 4 weeks. Mr. Che Gogoi accepts notice on behalf of. Ojai Deputy Commissioner is there
Lordship, then I can,
and Sub Deputy Collector also.
Lordship, I can.
What about Subdivisional Officer also you can
Lordship.
accept notice on behalf of respondents number 3, 4 and 6.
4 and 6, Lordship. 4 and 6.
What about Urban Development Department?
Urban development, yeah, standing council is shown, Lordship. Otherwise,
Who?
standing council is shown. Urban development, UDD.
Who is the Urban Development?
UDD.
And who is Director of Municipal Administration? Who will take that?
Lordship, we can, Lordship.
You.
Lordship.
Okay, Mr. K, go for 2, 3, 4 and 6, huh? What about number 1? Urban Development? Mr. P. Nayak accepts notice on behalf of respondent number 1. Petitioner takes steps for service of notice upon the respondent number 5 by registered post daily within 3 days. This is the matter after 4 weeks. You say, we have said issue notice, not returnable in 4 weeks.
Lordship,
I put it somewhere.
I prefer showing the GA Assam in the close list, Lordship.
Huh?
For GA Assam in the close list, I prefer.
Okay, the registry to reflect GSM in the column.
Already.
22 deep levels.
Right, these are Lordship.
You've got a monopoly on this admitted, this bill. What is this? This again water resources.
Under one thing, my lord, respond number 1 name, I have written wrongly, my lord. It should be irrigation department. Address are
Now what
correct,
to
my lord.
do? You've got to file an amendment.
Yes.
Only one.
Mr. Adam, it cannot, the CIA said we do not accept.
I'll file amended petition.
You file amended or you withdraw and file again better?
My lord.
I do not know. I leave it up to issue. We'll give you time, but you'll have to file amended
Yes,
amendment application,
Then
listed
withdraw.
and amended. Mistake.
S. Bora.
Acha, Miss S. Bora. Learner counsel for the petition. Oh, sorry, I mistook you for another lady. Miss S. Bora, learner counsel for the petitioner. Is there any admission of the amount here?
Yes, my lord.
Is there?
Yes.
Miss S. Bora, learner counsel for the petition. Says that she may be allowed to withdraw the writ petition with liberty to file a petition. Miss N. Upadhyay.
Two and three, Lordship.
Appears for point number 23, while Miss D. Jain appears for point number. Yes, and Mr. H. Ali appears for point number 4. The writ petition is dismissed as withdrawn. Comma with liberty of appeal.
All right, Lord.
Yes,
My lord, the item number 45, my lord. 45, my lord, similar matter, my lord. There, my lord, I have collected a copy of contract agreement, my lord.
And Lordship, I'm also collected some documents from authority today morning, Lordship, but it is not much legible. But there is a clause, Lordship, terms and condition, not in agreement. Arbitration clause is there, so I need some time to take proper instruction.
this is just an August bill. Right. Miss R.B. Bora, National Council for the respondents. Submits that she would like to be given some time to verify whether there is an arbitration clause which can be availed of by the petition. When do you want?
After a
This is the matter after the week.
deeply.
45 also.
Same.
Public.
Deep.
46. Similar method, Lordship has taken at item number 10 of today's main list. There, my lord, it was Lokmanya Tilak. Here it is Secunderabad Express.
What is this?
That was Lokmanya Tilak
Ah.
in item number 10. And here it is Secunderabad, it was agreement was for
Parcel van.
parcel van from Secunderabad to Guwahati. Now they have,
Where is your contract agreement?
my contract agreement starts at page, my lord, 35 annexure 4.
35.
This agreement,
Guwahati, Secunderabad Express.
yes,
Guwahati to Secunderabad,
Guwahati Secunderabad,
Guwahati.
Guwahati, down trip.
round trip. So now what is the problem in your case?
Problem is that, my lord, similar, they have issued these shockers notice along with the termination.
Ah, sure.
So that is page 61 is the impugn. One month's notice of termination,
Oh, okay.
and they have taken as a punitive measure. Although I have
Silchar, Secunderabad system. Oh,
filter increase and as per clause 21.1 contract agreement dated, I'm reading from para 3. Agreement
okay,
dated.
so they want Guwahati, Silchar also.
Yes. My lord, another funny thing is that, my lord, prior to issuing this 17 to 2024, they have issued the shockers along with the termination of the contract. On 16 to 2024, on the same.
No, yes, 1 month's notice issued on 17 to 2024.
On 16 to, they have uploaded the auction catalog in the website
Option color.
prior to 1 day prior. That I have annexed page 59. And auction is on the same day on 4th of March 2024.
When?
4th of March, Monday. They have prior to this.
4th of March. And this period also has not ended. What is going on?
Item 10, my lord, similar date, similar item 10, similar.
Okay, right. Item 10, who took the decision? Kalpana, okay. Anyway, heard, Mr.
Yes, now.
Yes, now. Learned counsel for the petition who submits that the impugned notice of termination dated 17 to 2024 and the auction e-notice, is it? Auction e-notice dated 20/2/2002.
No, my, that is the 22, it is the when I logged in,
Okay,
that day. It is 16 to 2020.
16/2/2024. Whereby e-auction of the
Parcel space,
parcel,
parcel space in parcel van,
parcel space
in parcel van
in parcel van
of
of,
12514. There,
where is that, where is that, where is that?
that my lord, bottom of the, that where, my lord, column to lot number category 12514 12513 BP1 Silchar Secunderabad 20.
Okay, page 59, this portion. Lot number category, this one, okay. Page 59. Should be set aside.
Yes.
This one. The petitioner's cause is submits. No, the petitioner's case is that a contract agreement dated 25/1/22 was executed between the parties for leasing of parcel space in parcel van. So and so at page 35, Yeah, from red to red. Red to red, okay. The contract agreement was for a period of 5 years from,
Guwahati. Ex-Silchar Secunderabad.
no, date, from
Date-
which period?
Date 5 years from 12/11 to my lord, 2011-2021 to
2011-21
my lord, 12/11/2026 at page 36 10.1
14/11,
page 11 36 1
up to 12/11/26.
12 and 20.
Next paragraph. The respondents, however, the respondents thereafter made a request to the petitioner for extending operation of his lease contract of running the parcel vans beyond Guwahati to Silchar, that is, the parcel vans would then run on a round trip basis from Secunderabad to Silchar and back. The petitioner declined the request of the respondent and by stating that he would operate the round trip from Secunderabad to Guwahati and back in terms of the contract agreement dated 25/1/22. Next paragraph. The respondents thereafter issued the impugned notice of termination dated 17/2/2024, stating that the contract would be terminated in terms of clause 21.1 of the contract agreement after 1 month expires. Next paragraph. The petitioner's counsel submits that even though 1 month has not expired, the respondents have now issued the impugned e-auction notice whereby the contract agreement is going to be terminated, even though there is no breach of contract by the petitioner. Further, the e-auction notice has been made to auction the Secunderabad, Guwahati and back parcel van lease that has been settled with the petition till the year 2026. on considering the fact that there is nothing to show that there has been any breach of contract on the part of the petitioner in terms of clause 21.1 and keeping in view clause 17.1 and 17.3 of the contract agreement, comma, the impugned notice, the e-auction notice. Page.
Page my lord 59.
The e-auction notice pertaining to sequence number AA-1. There's a page 59 again. This thing. It is red part. Comma, insofar as it covers the route from Guwahati to Secunderabad and back.
Right.
Shall remain state.
Right.
Till the next day. List the matter on Wednesday. Tag this case along with WPC number. Item 10. Item 10. huh?
117-117-2024.
Item 11-117-2024. Wait, one thing. Miss RB, Miss B Sharma CGC, submit that she will obtain instructions by the next date.
All right, keep it.
47. Wait, please, Your Lordship. Well, this is regarding e-procurement of supply of agro machineries and minor tools. The petitioner, his technical bid has been rejected.
Yes,
Technical bid has been rejected.
just a
And in
minute.
fact,
This
was
is for supply of agro machine and minor tools. Okay.
Yes, my lord.
Yes.
Now he's challenging his rejection of technical bid. And in fact, my lord, your lordship in a similar case, your lordship has already passed an interim order that covers my case also. My prayer would be, my lord, your lordship will issue notice or my lord,
But in
later
that
with the
case-
other matter and take up the.
Wait. No, your technical bid was disqualified on what ground?
My lord, the grounds they have stated are at my lord page, the bid committee at page, my lord, 123.
Page 23.
123. 122, they have communicated. Now, relevant portions of my lord, page at 120, 129. In one item, where the petitioner has been found responsive at page 129 top. But
What is your name?
my lord,
What is the party's name?
Trade Supply India.
Trade Supply India. Okay.
In the, my lord, serial number 3, he has been, it has been found responsive. But in other items, serial number 5, Trade Supply India not responsive down below. Not responsive.
No, so experience of solar lighting system, which cannot be considered as experience of particular item.
Yes, my lord.
Okay.
Solar light trap.
Then,
Huh?
The item was lordship serial number 5, solar light trap lordship.
Solar light trap. What is
Yes.
that? Solar light trap?
But that doesn't match this.
Doesn't match.
Next page also not sure.
Let me complete. Not much.
No, you have got to give them some leeway.
Okay, fine. Because I have got explanation, my lord, there is an appeal, the provision of appeal. I have filed an appeal. Without considering the appeal, my lord, the financial basis has been.
Without,
Without
without,
considering the appeal. Because there is a provision of appeal, we have filed the appeal. That has not considered and on the date of receipt of the appeal, they have, my lord.
okay, let us go to item 5, then item 6.
6 is also, my lord, found not responsive. Item 8,
Again, solar light trap.
yes, my lord. It's a system, my lord, similar system. I have in fact placed, I have got explanation.
I don't know, these things are technical. Anyway,
Now, my lord, the assessment was supposed to be conducted in August. They waited for so many months, we do not know. All on a sudden, my lord, they have done it. And also, my lord, upon the financial bid without considering my lord, appeal. That is my grievance, basically. So my prayer, my lord, let them open instruction. I am not praying for any stay today. And take the matter with the other case, one of that interim order covers me also.
One thing is that if he has filed an appeal, shouldn't that be decided first before you? Because
But
if
it was-
supposing the appeal goes in his favor, then what will happen?
Provision of appeal might not in the, they've stated in the NIT also.
For the delay, Lordship, I have placed an instruction, Lordship.
What delay?
So, for the delay of 6 months, Lordship.
No, that is a different. We're not on that. Why you took 6 months to decide? I'm not on that. Not now, at least.
Appeal will consider by tomorrow, Lordship.
You consider, because you see, the thing is that now it appears that it's a foregone conclusion. Or you might have already decided and it might not be to his knowledge,
We have not uploaded the financial bill, Lordship.
not uploaded. Okay, we issue notice from. Correct. All right, Mr. M.K. Chaudhary, Leonard Senior Counsel for the petition. What is the judgment that you have given me?
That is your worship order, my lord. Yes, no, this,
Oh.
now yesterday's order.
Okay.
Yesterday, your worship has passed an order, same tender, same
But
tender,
grounds are different, Lordship.
grounds on this.
Grounds
How's
of
that
rejection are different.
But then, my lord,
That
your
was a
worship has
big
stated that covers me, that's why I'm not ready for any same order. Same ground, appeal has not been considered. There are also other grounded that, my lord, the appeal was not considered. But there are other explanations the petitioner had. Last year, your worship will see. On consideration of above, they listed matter again on 6/3/2024 to enable Mr. Chaudhary to obtain further instruction. Status quo with regard to the NIT. That is already there.
But technically, they had qualified yesterday's case, Lordship. Because of the bank guarantee.
But if we are, my lord, if this is like taken separately, then I have to pray for interim also. But if it is connected, my lord, I don't know. Pray for interim. Let them obtain instruction.
So, you know,
Okay, right. Okay, Leonard Counsel for the petitioner who submits that the grievance of the petitioner is with regard to the petitioner's bid being declared unresponsive. During the technical bid evaluation stage.
Yes.
The petitioner's counsel further submits that an appeal dated
April 26/2/2024.
26/2/24.
Yes.
Has been submitted to the appellate authority.
Yes.
Against disqualification of the petitioner's technical bids. Which has not been decided till date. This is the matter on
6/3.
6. Too many matters are going to be discussed.
It is tagged, my lord.
They said it's different. With another date will give.
Then interim.
together it can come, Lordship.
Huh?
Together, both the matters comes in on the 60th.
For you, it's okay. For me, I'm looking at thinking of myself.
Tender is similar, Lordship. Both the tenders are same. Items
Parties are different,
Parties are
items are different, reason for disqualification is different.
But the ground is saying, my lord, that their appeal was also not considered.
Huh?
Their appeal was also not considered.
Yeah, this is the matter of 6.
Which, my lord, WPC 1174.
Huh?
On 1174.
No, let it be.
Regarding payment of bill regarding irrigation department, my lord. To the irrigation department. The only issue, my lord, admission is also there, my lord. Only issue, kindly see, my lord. That is page 42, annexure E, my lord. So. Annexure E. That is the issue. But no allegation against me, my lord. It is against the scheme, my lord.
This is what, this is with regard to that erosion thing.
My lord,
Is it regarding the water resource department or what?
no, my lord, this is, my lord, this is regarding irrigation department, my lord. Irrigation department. Irrigation department, my lord. A reply of the RTI, my lord, page 39, my lord.
But where is the admission?
No, my lord, kindly see page 39, my lord, that is the admission, my lord.
There is the reply of the, it starts from page.
Anyway, where is the other side? Who's the council?
Dipti Niyog, my lord, she told,
He knew
D Niyog, my lord.
what to do. Let her, it's a he or she?
She, my lord.
She. Right.
Dipti Niyog, she appeared last time.
Huh?
Last time she appeared, my lord.
Petitioner's counsel is present, however, no one appears for the respondent. Accordingly, in the interest of justice, this is matter. Absolutely.
She time for respondent number 6, accountant general.
We have got no role.
All right, ma'am.
Maybe the lordship, matter is relating to non-payment of contested.
Yes, where's the admission?
My colleague here, he some difficulty today. So if you don't, no, 24 order passed. Admission is not there, my lord, but
So you obtain instructions?
my lord, or else my lord can dispose of the matter by directing the authorities to verify the claim of the petitioner.
No, no.
Or my lord, I will inspect.
As per Township Rally, it has to be
Yes.
admitted.
Yes, ma'am. I will have the instruction.
Mr.
S. Niogi, my lord.
S. Yogi Land counsel for the respondents shall
All
ob-
respondents.
shall obtain instructions with regard to whether the amount claimed is an admitted amount. Leave the matter after 2 weeks.
25 is
After
my
3
lord,
weeks.
regarding
Same.
reward note. Yes.
Huh?
Only the construction work and the precedent is different. Petitioner is different, but it's
So you
related to
you need instructions again, same order.
Highly obliged.
Highly obliged.
Lordship,
What about
kindly pay.
26? 26? Application? Oh,
Lordship, kindly peruse the order dated 8/1/2024, Lordship.
yes,
Deputy Commissioner was directed to cause an inquiry, demarcation, and to thereafter file his report in a seal cover.
Yes, my lord. I have received a letter yesterday, my lord. They said that they are required 2 weeks time to furnish the report, my lord.
okay, right. Mr. M. Chetia, Learned Counsel for the state respondent submits, he has received a letter dated
29 to 2024.
29,
To 2020.
29 to 24 from the
From the sub-divisional officer of Bogota, my lord.
SDM Barpita,
SDO Bogota, my lord.
Barpita,
SDO Bogota, my lord.
SDO. From the SDO SDO bracket S, Sadar, Barpita. Stating that they require a further 2 weeks time for preparing the report in pursuance to the order dated 8/1/2024. Accordingly, this is matter after 2 weeks.
Date may be fixed, Lordship, or 16, Lordship. There are 16. I can 19, Lordship.
May please your lordship. Lordship, in this matter, the grievances of the petitioner has been mitigated, lordship.
Huh?
The grievances of the petitioner has been mitigated.
Okay.
Therefore, I humbly beg that,
Mitigated? Mitigated means lessen.
lordship,
Huh?
the process has been initiated. That's why I'm
Okay,
saying
okay.
mitigated, lordship.
So you do not want to press this
I
matter?
don't want to pay, but
Okay, Mr.
PP made it, lordship.
PP made it and counsel for the petitioner. Says that he may be allowed to withdraw the writ petition, come out with liberty to file afresh. Come in as much as no, that's all. The prayer of the petitioner's counsel is allowed, writ petition is dismissed as withdrawn.
I'm deeply obliged,
With
lordship.
liberty is paid for.
May please. Lordship is admitted fact. Contact will, my lord.
Yes, go away.
My lord, it's evident can be on Thursday, my lord.
Why?
That's admissible part, my lord.
Admissible,
Admitted or not?
They have to annex some document, but my lord, let me have it from the authorities also, my lord, on Friday or Thursday, my lord.
Okay, which document are you, which page? Admitted amount, which page?
Page amount.
Sanction they-
4,70,7.
I'm talking about which page, where is the document admitting the
Admit-
amount?
Annexer, my lord. Seven.
Page.
33,
Huh?
33.
60.
Proposal for my lord, clearance of the
Bill passed, my lord, already. The 3 number of bills, my lord.
Mr. Counsel, where is the admission of the amount by the respondent?
Bill has been passed, my lord.
Where is the bill pass? This is handing over and taking over report.
Submission of past bill for.
Which page?
Page 33. 33. Annexer 7.
So this is the amount you're claiming,
Yes,
2,85,000.
three bills.
one is 2 lakhs, one is my lord, 1,25,000.
1,20,000.
And
Okay, right.
68,000.
Mr. B. Gowai, please for time to obtain instructions with regard to whether the bills as reflected in page 33, 37 and 41 of the writ petition are admitted amounts.
No.
When do you want?
On 11, my lord.
This is the matter on 11. Can we finish off the others? Yes, we'll just finish off the others. That those others won't take like time.
Orders.
May I please your lordship? Lordship inadvertently stay was not taken upon respondent number 4. Monday, we will take first step.
And for respondent number 6 to 17.
So what is to be done?
Time maybe given for them to file first.
Monday, we will take the first step.
But the issue is regarding compensation.
Yes, lordship.
That is between the there's a title suit going on.
Yes, lordship.
Then why don't you go there? What is this court to do with it? What is the role of this court? You all are fighting over compensation,
Yes, lordship.
the brothers.
Yes.
What has this court got to do with it? You all are fighting, there's a title suit between you all. So you all go there. What?
Lordship, take some time, please, first step. That's for respondent number 4.
Okay, right, Miss
R. Dev,
R. Day.
R. Dev,
Are they appearing on behalf of
S. Chauhan.
S. Chauhan, learned counsel for the petitioner? Submits that she will, steps for service of notice upon the respondent number 4 will be taken by Monday.
Monday.
Accordingly, let this matter after 3 weeks.
Obliged.
Then 34 to 39.
Contextual labor. Contextual.
In these cases, lots of direction was issued for listing the names of the petitioners as per cultural adjustment laws. That has been done, lots.
So what remains?
Lordship may, subject to my friends, we close this meeting.
But the lease is not, the lease.
But they will
given by
list
the
41
district is,
parties in one copy, Lord.
He's going to furnish the list.
One copy may be served.
The market sees aware now. It sees aware. I'll furnish a copy.
Okay, right. Miss A. Bujar Barwa, learned counsel for the petitioner. Appears for the,
34 to 39 extra to look at.
please, please mute your microphone. Appears for the petitioner. In view of the alleged violation of the order dated 8/4/2021, passed in WPC 4415/2020. Wherein the claim of the petitioner was to be processed in terms of the judgment of the full bench of this court in the case of Shamsher Ali and others versus State of Assam and others, 2008 4 GLT 1. Full stop. Next para. Mr. No, no, Mr. P. Nayak, learned counsel for the respondents, submits that in compliance with the order passed by this court, the name of the petitioner has been included
Yes, sir.
in the list to be verified for payment of contractual bills in terms of the full bench judgment of this court in Shamsher Ali Supra. Full stop. He accordingly submits that the contempt petition can be closed as he will be, as he has provided the list which shows that the petitioner's name has been included in the list of persons to be verified for payment of unpaid contractual bills. Full stop. Next. On considering the submissions of the parties and on noticing that the list has been given to the learned counsel for the petitioner, the contempt petition stands closed.
I think 39,
All,
Similar.
in all cases similar.
but with number of repetition is different. But petitioner is the same.
And numbers will be different and the court cases will be different. WPCs will be different or same.
WPCs are different, contempt cases are also different.
So,
You know, 34 to 39.
it'll be different orders and different petitions, huh? Yes.
Item 40.
Yes, Milords. Milords, in this matter, Milords, I am appearing, Milords.
Yes. What is
I am
your,
appearing for the petitioner, Milords.
yes,
Milords, the section 11 petition
yes,
for appointment of the arbitrator, Milords. There is a arbitration clause, Milords. I have invoked the arbitration clause as per my notice, Milords.
what does the arbitration clause provide for? Is there going to be an arbitral tribunal or a sole tribunal or a sole arbitrator? What does
Milords, now, Milords, because as per the railway rules, Milords, they are generally, it's a tribunal. But I am before you, Milords. That's why I am just saying you appoint anybody, Milords. Any retired High Court judge, Milords, or any ADJs, Milords, there, Milord, then we will, I have no objection, Milord, because they have not responded to my notice, Milord. Once I have issued a notice, they have not come forward, Milord. Neither they have recommended any name.
My lord, Mr. Gupta has left the court, my lord. He is
Why?
feeling unwell. my lord. Taken a part any day.
So, did you hear the counsel for the respondent, Mr. Petitioner?
Milord, I have not heard what he is saying.
What he's saying is that the CGC is suffering from fever and has left the court. So they
It's
are
all right,
asking
Milord,
for
then,
adjournment.
Milords, I am not pursue, Milords, because it's a council request, Milords.
So we will adjourn the matter.
It's all right, Milords. Kindly have it any short date, Milords.
What is your name?
Fayaz Hassan, Milords.
Mr. Fayaz, your affidavit.
Fayaz, Fayaz Hassan.
Where is your wakalatnama?
Yes, Milords, I have already signed the Wakalatnama. Wakalatnama has been signed by me, Milord. Once it has been filed.
It's filed.
It is fine.
Okay.
Yes, Milord.
Mr. Fayaz
Hassan.
Hassan Hassan appears virtually for the petitioner. Mr.
Why Borbuya?
Huh?
Why Borbuya for Mr. H.
Y. Borbuya appearing on behalf of Mr. H. Gupta. learned CGC, submits that Mr. H. Gupta has suddenly taken ill and has left the court. Here, full stop. He accordingly prays for adjournment. Full stop. The same not being objected by the counsel for the petitioner, lists the matter. 13th. Okay, 13th. Okay. 13th too.
Highly
Obliged, my lord. Highly obliged, my lord.
Yes, Miss, where is this? 41.
Lordship, as per the last office note dated 7/2/2024, it stated that the notice issued to the sole respondent has been directed to the registry with postal endorsement always door locked. And on 3 dates, they tried to serve some notice to the sole respondent, but his door is always locked, it seems.
From inside or outside?
That is not mentioned in the endorsement.
Now that is the problem. If it's locked from the inside, then we get some inference.
Yes.
If it's locked from the outside, then what to do?
Lordship, we might, if the court allows, we will do a paper publication.
No, but then, you see, that doesn't solve the problem. Supposing his door is locked from outside, then maybe that he's not there anymore.
But in the office note, it's not mentioned, it's only written.
That is
always
what,
door.
so that's what. So supposing he's living somewhere in Jammu and Kashmir. Will a paper publication here help?
The court.
Who is the respondent, this respondent?
Lordship, the address is from Dispur, Guwahati. Is,
Can you serve notice, Dusty?
is
Huh? Right. Mr.
G. Kaushik.
G. Kaushik appears for the petitioner. The present application is for appointment of an arbitrator under section 11 of the Arbitration and Conciliation Act 1996. Mr. The office note dated 7/2/24 states as follows, huh? In view of the above, the petitioner is allowed to serve notice upon the respondent by way of dusty service and file affidavit of service thereafter. List the matter after 4 weeks.
Yes.
42 and 45.
Obliged.
I got order complied with financial sanction has been given. Lordship will see, my lord, just above, my lord, terms and condition. Above terms and condition,
Yes.
it has been, financial sanction has been accorded. In fact, my lord, beneficiary details has been given, it will be deposited in his account.
Okay, right. Item, this one is item 42, huh? Item 42. Heard, Mr.
F for it,
F. Farid, Faridi,
for it.
learned counsel for the petitioner, who submits that the order dated 27/1/23 passed in WPC 2855/22 has not been complied with. So, sir. Mr. B. Gogoi, learned counsel for the respondent, for the PWD. This is a contempt
For them.
for the respondent,
Whether there it's still in service, my lord, that I can.
for the respondent.
Respondent.
Submits, for the respondent submits that financial sanction date 8/2/20, no, the letter showing that financial sanction for payment of the bills of the petitioner have dated 8/2/2024 has been submitted to him, which shows that the financial sanction for payment to the petitioner has been given for rupees 23 full stop, 23 comma or what? So for 23.73902 lakhs, huh? 23.73902 lakhs. Full stop. The petitioners, the causes for the parties both submit that in view of the above, the contempt petition can be closed. Full stop. Next, in view of the consent of the parties and keeping in view the sanction letter dated 8/2/2024, the contempt petition stands closed. The sanction letter dated 8/2/2024 is made a part of the record and marked as Annexure X.
Civil ballot, only one word in Lakshmi indicate ballot, sanction letter issued by the public works department.
Acha, sanction letter dated so issued by the Public Works Department.
By the road.
Public Works Roads
Road.
Department. Huh?
How like-
Then in the other case,
What's
Second.
the figure, same amount?
amount will be different, I think. Out here, the amount is 23 full stop 65232.
23,65,230.
And the letter, sanction letter is 26/2/2024. Again, out here will be Annexure X, no?
Publish that. Publish.
Finish?
I mean 32.
My lord, my learned counsel, Mr. Doctor, informed me that he has got some business in the court of Honorable Justice Sriwana. So he informed me that will be informed you.
That's what it informed you. What? Louder, Mr. Council? I can.
Mr. Doctor has got some business in. the court.
He's got okay, he's got a hearing in some other court. So what to do?
It depends upon your lordship. He just told me to inform people of it.
Your Lordship, he is in the opposite courtroom. May I call him?
Yes, you can call him. Yes, so what to do about this case? Otherwise, if I don't start the conversation, we're just going to stare at each other.
I will take fine and affidavit. Additional affidavit, which was earlier they filed, but when it's done and the first affidavit is filed. In this
Fresh
affidavit,
affidavit filed by whom?
by the respondent number 3.
Huh. To what effect?
Disclosing the strength of the post of ward boy, ward girl, and assembly. Lordship will find that at page 119, 119, in paragraph 4. Oh. Possibly 106. There was a restructuring of marking.
Issued when? 4th January.
No, 20, filed on 27/2.
27 true.
2024.
27. Okay, at 118.
The lordship is 118. Okay. Then in 119, paragraph 4, my lord, the strength, sanction strength we have elaborated there.
Number of posts, so sanction strength of what girl and what boy is 58.
58.
Number of posts filled up is 43. So there are altogether right now 15 vacancies.
No, vacancies, my lord. 12 in this interview, my lord, they have been selected. Because of the status quo order, we could not accommodate them yet. Now, 3 of the posts that and 3 of the these attendant we could not appoint. That is the final hearing is posted on 4th March. In that case, so all the these posts will be filled up, my lord. 58 posts.
And
Now-
what about the petitioners? Where do they stand? They're nowhere, they're not included
Their
here.
position is, my lord, they have filed a reference case in the before the industrial tribunal. It is pending there. So, my lord, their problem is that whether they are entitled to get 1/3 of the salary. That is in challenge in the reference court.
Is it? No. Where is that reference code?
They are for reinstatement also is there in that reference. No, my lord, don't confuse yourself. My lord, I'll take your lordship slowly.
No. What is the order before the tribunal? Let us see.
Yes. My lord, your lordship may see the first thing your lordship can kindly see.
Chairman,
The
you've got
term of
anything to
reference.
type? You've got anything to type? No work. Free.
But the lordship may look at term of reference.
Just a minute, just a minute. Yes,
At page 80, my lord, term of reference.
page 80.
Yes. Your lordship may kindly see page 80,
80, yes.
the schedule. Number 1. Whether oral termination of the services of Sri Mainul Haq and Foni Deka, workmen with effect from 9/9/2019 by the management of Dr. B. Burua Cancer Institute is proper, legal and justified. If not, what relief these workmen are entitled to, what directions, if any, are necessary in the matter. This is in respect of petition number 1 and 2. And so for others, number 2, whether the demand of Mainul Haq and 14 other workmen listed attached for payment of wages at the rate of 1/30th of the pay at minimum of the relevant scale plus dearness allowance as applicable to regular employees of Dr. B. Burua Cancer Institute as daily wages for doing regular nature of job in Dr. B. Burua Cancer Institute is legal and justified. If yes, to what relief these workmen are entitled. Now, this reference is pending before the tribunal. Now, they have come here. You'll also kindly see what in the reference code, what application they have filed. The lordship may come to page 83, my lord. Page 83, it's a reference case number 2 of 2021.
Yes, page 83.
That the paragraph 1, my lord, that the above noted case is pending before the honorable court for legal remedies for the 15 numbered ward boys and girls working under the respondents. And the respondents have full knowledge about the pendency of the case before the honorable court. That the respondent number 4 arbitrarily terminated the applicant number 1 and 2 without valid ground and without following the provisions of laws and remaining 13 numbers ward boys girls who were working under the office of the respondent till 30th June 2021. That on 1st July 2021, the respondent, without giving any notice in writing,
and without indicating any reasons for retrenchment and payment for retrenchment compensation or any other valid ground, arbitrarily terminated the remaining ward boys and girls, those who were present in duty, and directed the concerned department and their internal security personnel not to allow to enter those ward boys and girls who will come to attend night duty without prior written permission from the honorable court, which is an illegal steps and taken by the respondent during the pendency of the proceeding. My lord, this statement is utterly false, my lord. Even they are working, till from that date, they are getting their salary and all that. Now, on the basis of this application, what tribunal has done, tribunal has passed in status quo order on the next day. Now, supposing, my lord, we have ousted them on 1st July, whether the status quo order will have helped them is no at all connected. Because if you are ousted, you are ousted. But this statement itself is a totally false statement. We never ousted them. Till such time they are working, still they are working. And the reference case is pending before the tribunal. Now, this is their case. Now, prayer your lordship kindly see at page 85. It is therefore prayed before your honor to kindly admit the petition considering the above facts and circumstances. It is humbly submitted before your honor to kindly direct the respondents to reinstate those ward boys and girls considering the pendency of.
Where is the status quo order?
Yes, status quo order you will find at page, my lord, 88, my lord. Page 88. Order dated 2/7/2021. Case record is put up. His lordship got that. Case record is put up today along with petition number so and so. Seeing the petition submitted by the concerned workman stating inter alia the following: that on 1st July 2021, the respondent, without giving any notice in writing, your lordship has seen that. Your lordship may skip this. Hard learned counsel, Mr. So and so, appearing for the concerned workman, he has submitted that in view of the provision of section 33 of the IDA, such adverse action toward the concerned workman by the management during pendency of the proceeding before the tribunal is completely illegal. He has also prayed for passing an interim relief order so that the concerned workman cannot be thrown out of the job by the management without following the provisions of law. It appears from the record that the case is fixed on 13/7/2021 for filing of written statement by the management and necessary order on the petition number 67 on 21, submitted earlier by the workman side. Having heard the learned counsel appearing for the workmen, and also having gone through the petition and other materials available on record, it is ordered that the concerned management shall maintain status quo in respect of the employment of the concerned workmen of this reference case till the next date of the case, till 13/7/2021. Now, status quo order, my lord. Supposing status quo order,
Supposing they were out.
still it is there. My lord, then what will happen? We cannot oust them. We cannot oust them because the reference case is pending. Otherwise, what will happen? We shall answerable to reply under section 33A and B of the Industrial Dispute Act. So therefore, it's not a case that we are going to oust them. And right from that day, they are getting their salary and all that. They are working in the institute. My lord, my learned friend will agree with what I'm saying. They're still working there. They're getting their salary and all. So my lord, now supposing the status quo order is still there, then the consequence of the status quo order is that we cannot oust them. Now, can they say that the fresh recruitment process at the instance of the casual workers, in terms of the advertisement rules, they are not a party to that. They did not apply for selection and all that. Now, can they stop the selection of these candidates? This is the only question, a very minimum and basic question is required to be answered by them. This is very short in nature, my lord. And if my learned friend says something, and I reserve my right to reply to it. Because the appeals court has said under what circumstances, and your lordship kindly see. Other day, some questions arose. Now, the appeals court has replied that I will face before your lordship. Let me go to those things now. Well, I'll take your lordships to judgment of the appeals court 2020-17 SCC, page 401. Your lord- Yes, I am also feeling it's a bit colder. The weather is very fluctuating now. Sometimes you feel warm, then again. Look, can I take your lordship to paragraph 11.4?
11.
Man, 11.4.
Yes.
The petitioners who did not willingly participate or having participated on previous occasion have been held to be unsuccessful, cannot assert a violation of their fundamental right. Now, in this case, your lordship will find out of all the petition, only one person participated. She was called for the written examination. She did not turn up. Now, besides her, nobody.
Which one of the writ petitioners?
One of the writ petitioners.
Which writ petitioner?
Yes, my lord, your lordship may. That is at page 5. 14, my lord. Petitioner 14, Srimati Bhanita Burman. She was shortlisted in the written examination but did not appear. Now, this is 11.4. Then
So there was a preliminary examination held or something?
a written examination, then interview,
Okay.
skill test.
So because you said she was shortlisted.
Shortlisted for written examination.
What do you mean? So there were a lot of disqualified candidates or what?
No, my lord, there are many other candidates. She also participated. And she did not appear in spite of calling.
My lord, may I say?
Huh?
May I submit something?
What?
May I submit now? He's in the middle.
Hello, let him say if you want to say something.
Hey, okay, what do you? My lord, these petitioners have been working in the BBCI since last 5 years to 17 years. Now, at present, I think 18 or 19 years. They were appointed as casual on with daily wages basis. And they have been working without any interruption, without any break. Even they have been provided with just experience certificates showing their period of services, nature of job, etc. And assured them that they will be regularized in due course. Subsequently, after taking over. This is not a government hospital, is it?
So it's autonomous, I mean, it's by Atomic Energy. Government of
Nowadays, it has been taken up by the
2017, it has been taken over
by the government.
by the
By the
government.
government.
The administration are under Tata Memorial Center. My lord, what my learned friend is saying,
My lord,
well, you have a chance, but why you are not participating?
my lord, just let me speak. I am not interfering. My lord, the petitioners again and again. He tends to interfere actually. My lord, petitioners once again since 2018, after the advertisement made by the first advertisement made by the Tata Memorial Center, then they raised the dispute, and they prayed for. Once again, they prayed for granting some relaxation. Even they paid for relaxation of qualification and ages, etc. But the management did not agree. Ultimately, during pendency of this reference case before the Pradesh CJT Guwahati, they have made another advertisement that is 27
Second. Page 20. Page 28.
28. No, page 28, my lord. During the pendency of this reference case, this advertisement has been made. In the meantime, the London presiding officer CJT has been retired more than 1 year. The court is vacant. Therefore, finding no other alternative, we have approved this honorable court for relief. So the reference case is now can it start? Is there no officer over? No.
I think someone.
No, that was in Midland. That was in Midland.
Now, none has been appointed. But then what relief, my lord, they are asking for, let him say.
No, but then you see, the thing is that your advertisement has been issued subsequent to the reference case.
Yes, my lord.
So, but then when
Subsequent to reference case, as well as subsequent to the order of status quo passed by the order CJT. Whether status quo order, by virtue of status quo order, we are restrained from advertising to fill up
no,
the.
not restrained, but then once the post once the posts are filled up, then you say that there are no more posts.
But the question would be, my lord,
My lord,
reference to the tribunal decide the reference matter. So far, ousting of them is not coming up at all. Now, here was an advertisement. You did not participate. Who has stopped them to participate, my lord?
my lord, they have lost their whole qualification because during the long tendering service, they have spent 16 years, 17 years. Yeah, what girls and what boys? What
Yes.
girls and what girls?
Now it is said to be, my lord,
Attending. Now, if they are what boys and what girls, and if you fill up those posts, then where will they go to? Supposing they win in the tribunal,
if they win in the tribunal, my lord,
where will they go to?
no, that, my lord, your lordship kindly see. The sanction post, they will have to create. If supposing your lordship passes an order, if the reference court passes an order to create a post, they will have to create it. There is no
No,
problem.
we can pay that, we don't have that much.
But then only thing
It's
here,
it's not like earlier time.
but
All is different, you know better.
my lord, let him place his case, then I will reply. Let him complete.
My lord, my land is when submitted that there are only 48 number of courts, 50. But actually, they have also engaged some some workers from outsourcing. Outsourcing provided by one service provider, Pigeon company by name. 95 workers are working. While client has collected information informally from the BDCL regarding the total number of workers working as ward boy, Odgar and paid helper.
Is there not pleading, my lord? No, where from here?
Yes, if
You haven't pleaded.
no. It is the latest development on the basis of your submission of the affidavit. If, my lord, if I may be allowed to submit an affidavit regarding the information which my client collected with his. What is the information? There are altogether 159 workmen still working. 159 workmen still working, including the outsourcing person. $159 workmen outsource. No, my lord, including the outsourcing workers. Including the outsourced workers, there are 159. 159 people. How many outsourced workers are there? Outsourced 95, my lord. 95? Yes, sir. So what do you want to show by this document? There are sufficient workers. So there is no lack of workers. That is attendant on state page and they are pulling on that. Business. Pulling on. They are pulling all the doing all the services of attendant and page. So while other times always stressing that there are hurriness, there is some emergency to recruit a new person. But my petitioners, they are working as ward boys, radio operator, assistant, all sphere of activities they are doing. So there is no harm to retain this worker for the time being, till disposal of this reference fee. Where is their appointment orders? A petitioner's appointment order? Petitioners have not been appointed by them in any following the formal procedure. They came and they have been appointed and they are working since the date of inception of this Bureau of Cancer Institute. There is no advertisement, nor any interview.
Initial appointment was not the process of selection.
Anyway, that time it was a private thing.
Yes, that time it was private.
And they are working till this time. So my answer is to maintain the status quo till disposal of this reference case. Just to avail their fundamental right. If the tribunal decide that these are illegal, we will have nothing to say. But since the matter is pending before this tribunal, and status quo is also still being maintained. They have. This tribunal has not been functioning since when? Since November 2022, my lord. November 22, let me see the orders. Who makes up the industrial tribunal? Who is the presiding officer? Presiding officer. Presiding officer was
November
Mr.
2023, nobody is working.
It's manned by whom usually?
I think Labor Department.
Labor and Employment Department.
Judicial.
From
District judges level.
retired district judge as well as High Court, Honorable High Court judges also. In this
No, no.
tribunal,
Yes.
district judge, no, there has to be someone. Who is the admin?
Labor Department.
Labor Department, Dr. Indian, I guess. But the Central Industrial Tribunal is not. So this CGIT.
CGIT.
Yes, right. CGIT, for the post of, for CGIT, I don't think any judicial officer.
No.
Administrative officer, correct? State is judicial. But it's a CGIT, it's
Most of the judges will retired district judges are appointed.
It's a CGIT.
Till now it was, but someone came from outside, he was administrative.
CGAT is run by retired distinguished with 10 years experience. As well as Honorable High Court judge. Can you ask someone from the registry, admin or something? Yes. Who is the, pilot, so far I have come to know, at present there is no presiding officer. I don't know, let us verify. In the CGIT?
Yeah, he talked about registered.
No. Presiding officer. In the CGIT, center. Yes. You find out.
In the last Melod, M.K. Bhattacharya, he was a judicial officer, grade one. Melod, what? Melod, the last time, I remember my learned friend was the presiding officer there.
Who? In the CGIT?
Yes.
Yes, ma'am.
His Melod earlier, grade one Melod, judicial officer. CGIT very often it is like it. Someone will come, then after 1 year, nobody is there.
Rajkoa, you can ask Rajkoa, the registrar. Vigilance. Actually, all these issues should be taken up together. Pilot, for filling up the post of presiding officer at CGIT, for filling up the post of presiding officer at CGIT, central government in the Department of Labor and Employment made an advertisement on 27th October 2023. I think the process of appointment is already pending, going on. Page 97, my lord, the advertisement is there. What is your prayer? Yeah, one prayer is that to quash and modify the advertisement dated 31/10. Second is to allow the petitioner to participate in the recruitment process.
This has become infractious. Melod, if you look at to quash, modify the MPN advertisement dated so and so published in the Aswan Tribune, the daily dated so and so. Then, my lord, your lordship, at page 25, and to allow the petitioner to participate in the recruitment process for the post of attendance and paid helper, relaxing the age and qualification. Now, in the interim, stay the operation of the MPN advertisement. All this has become infractious. The advertisement took place, they did not taken part. What remains to do?
The entire selection can go if this is set aside.
My lord, set aside is a different issue altogether. The core question would be, my lord, daily wages worker whose case is pending before the tribunal. Now, by virtue of, if your lordship look at the initial order passed by this honorable court, my lord, I posed that very pointed question to the learned judge who passed the initial order, that whether your lordship is interfering with the selection process. My lord, the lordship answer was not at all. I'm just on the seeing the status quo order. Your lordship, kindly see the order dated 13/12/2023, passed by this honorable court. Now, heard Mr. So and so, the petitioners are ward boys, ward girls working in the Dr. B. Guru Cancer Institute, Guwahati, for a long period of time. The said institute, however, has been taken over by the central government and being run as the Tata Memorial Center. Apprehending that the services of the petitioner should be terminated, a dispute was raised which is presently a matter of adjudication before the learned central government industrial tribunal from Liverpool, Guwahati, in reference case number 2 of 2021. It is contended that in the said proceeding, there is an order of status quo also.
Just a
However,
minute, just a minute. The petitions are what? Yes.
However, due to the vacancy caused in the post of the presiding officer since May 12, 2023, the said reference case has not proceeded. The petitioners apprehended, these lines are important, my lord. The petitioners apprehended that in violation of the said order of status quo, new incumbents should be inducted as attendants and paid helpers. The job will be similar, and the same would cause immense prejudice to the petitioner and would also be in violation of the order of status quo passed by the learned CBI. The so and so learned council has also placed before this court a copy of the admit card so and so, so and so. Let notice be issued. Then the last two lines, my lord. Heard the learned council on the interim pair. Though this court has not put any embargo on the selection process, it is directed that no appointments be made of fresh candidates. The status quo order passed by the learned CGIT dated 2/7/2021 be maintained till the next returnable date. Now, this status quo order 2/7/2021 spent its force long back. Thereafter, my lord, this order was not continued. Now, for argument's sake, my lord, not accepting this status quo order continued, but even if it is continued, now what will be the result of it? At best, my lord, they cannot be ousted from the service. But this status quo order never says you cannot go ahead with any fresh recruitment process. So therefore, I pose this question to the learned judge. My lord, his reply was, I am not at all interfering with that. The order is very clear. The status quo, then, my lord, the learned single judge asked us to produce the certified copy. And the last occasion, my lord, we placed to your lordship. Your lordship kindly find that after 1611, there was no interim order. 1611. My lord, I'll take your lordship to those. There's no.
What is this?
Yeah. This honorable court passed an order because the status quo order passed by this honorable court in view of order dated 2/7/2021. Then, my lord, after that, some point of time, this order was not extended.
No, what is the status of co-order passed by the?
Yes, the status quo order 2/7, your lordship will find the first order, 2/7/2021. Earlier I read this, again I am reading, my lord. Case record is put up today along with petition number so and so. Seeing the petition submitted by the concerned workman stating inter alia the following. That on 1st July 2021, the respondents without giving any notice in writing and without indicating any reasons for retrenchment and payment for retrenchment compensation or any other valid ground, arbitrarily terminated the remaining ward boys and ward girls, those who were present in duty and directed the concerned department and their internal security personnel not to allow to enter those ward boys and girls who will come to attend night duty without prior written permission from the honorable court, which is an illegal step taken by the respondent during the pendency of proceeding. Third learned counsel, so and so, he has submitted that in view of the provision of section 33 of the IDA, such adverse action towards the concerned workman by the management during pendency of a proceeding before the tribunal is completely illegal. He has also paid for passing an interim relief that the concerned workman cannot be thrown out of job. Your Lordship, can you see the language? Cannot be thrown out of job by the management without following the provisions of law. It appears from the record that the case is picked on so and so for filing of written statement by the management and necessary order on petition number so and so. Having heard the learned counsel appearing for the workman and also having gone through the petition and other materials available on record, it is ordered that the concerned management shall maintain status quo in respect of the employment of the concerned workman of this reference field so and so. Now, status quo in relating to, as the Lordship has said, in respect of employment of the concerned worker. Now, these orders, continued, the Lordship may come to page.
You see, one thing, now I just got this, there is one Mrinmoy Bhattacharjee.
Yeah, earlier he was a judicial officer grade 1 here. No, he's a retired, retired.
So he's no more the.
No, he's
Retired.
long back.
He retired. Thereafter, lane to be appointed.
From the outline benches, someone used to come, now.
But sometimes they used to come, sometimes they do not come. Orders are being passed, like manner. Fix such and such date for hearing, such and same order. And this has been done by the secretary to the court. They report to secretary to the court of CJAT. The order sheet, my lord. Somewhere it is written MK Murthy. Somewhere one of the learned member, Dr. Shailendra Kumar Thakur.
But can you, supposing he wins in the CGIT, where will you accommodate him?
I could not get it.
Supposing his the attempt to retrench is held to be bad in law, and then he has to be accommodated. Where are you going to accommodate him?
My lord, in such eventuality, my lord, they will have to create force because the court's order, unless it is interfered by the higher forum, my lord, they will have to pay.
But you have seen the judgments of the Supreme Court. You cannot order creation of force.
No, the case is like this, my lord. If I, my lord, some of the decision of the appeal court. Now, merely because you have been carrying on for long 20, 30 years, and if your initial appointment is not through process of selection, you cannot ask for regularization.
But then they're not government servants. They were not a government entity earlier.
No, even the law will apply at the same force, my lord.
No. No.
Now,
Why?
in that case, my lord,
Why not? Why you say for a private shop, they want to hire some helper. They don't need to issue advertisement. They can.
in private, of course, my lord, it is the,
This hospital also was private at that relevant point of time.
at that time,
Yes,
my lord.
It was private.
Now,
But then, now the issue is when it became government,
my lord,
there must have been some terms and conditions incorporated between the hospital and the government as to what would be the fate of its employees. There must be something.
my lord, very correct. My reply would be, now, when you are to be regularized, just not like that. You will have to appear in the selection procedure. They have been,
No,
the
so
advertisement is
let
there.
us see the terms by which this hospital had been taken over by the government and what was the clauses that had been placed stating as to what would be the fate of those employees. There must have been something. I don't think they can just come in this like that and,
We can see to that.
just see, let's just see that. There might be something. You see, because
Otherwise, my lord,
at the end of the day,
yes.
their fate kind of in, they'll be thrown out of a job at the end of the day.
Thrown out, my lord, it's up to the tribunal, my lord. What,
No,
what
no,
they
no,
pass,
no, up to you, up to the management. You're not having, at the end of the day, you're going to kick them out, probably. Supposing tribunal, it doesn't go in their favor, you're going to say, look, tribunal is not in your favor. out.
tribunal is only, my lord, so far these 13 employers are concerned. It is regarding to the wages. They are not going to be thrown out.
No,
Your
no,
lordship has
no,
seen-
no, but then at the end of the day, that will also come into play.
No, my lord, I don't, may I submit something. My lord,
Anyway,
regarding,
let us see that agreement.
that we can.
Let us
But
see that agreement.
before that, my lord, I want to clear up certain position of law. My lord, the relaxation was given to them. Nonetheless, they did not appear. Now, regulation cannot be automatic. You must appear in the examination and the interview. What they did not do anything. One person came, and then when she was selected for written test, she did not turn up. Now, what right they have, my lord? Merely because you have worked for 17 years, does it mean you will
But
not
you
sit
see,
for?
that is correct, you're correct, but one thing you've got to understand, these persons who have worked for 17 years.
No,
More than 17 years.
That position,
Okay,
someone maybe, but then you are now overaged.
no, so just one thing is that, now to compete with the young blood, that legal acumen is not there, I mean, that the brain is not functioning, and
That's true, my lord.
so that is, you see, that is again, after working so hard for so many years for the hospital, and to ask them to compete with the young blood is, I mean, it's going to be a tough job.
Your lordship's query, I do respect, but then how the Supreme Court has dealt, my lord, I'll just take your lordship to those paragraphs. I think I have given this judgment to your lordship. To the 2017 SCC, can I take your lordships to paragraph 20, my lord?
Yes.
Your lordship kindly come to paragraph 21, my lord.
Yes.
The legal principles which govern the determination of a cutoff date are well settled. You know, they are talking about relaxation and all that. My lord, that's the reason I'm highlighting this. The legal principle which govern the determination of a cutoff date are well settled. The power to fix a cutoff date or age limit is incidental to the regulatory control which an authority exercises over the selection process. A certain degree of arbitrariness may appear on the face of any cutoff or age limit which is prescribed. Since the candidate on the wrong side of the line may stand excluded as a consequence, that however is no reason to hold that the cutoff which is prescribed is arbitrary. In order to declare that a cutoff is arbitrary and ultra-wide, it must be of such a nature as to lead to the conclusion that it has been fixed without any rational basis whatsoever, or is manifestly unreasonable, so as to lead to a conclusion or violation of Article 14 of the Constitution. Now, several decisions of these court have dealt with the issue. In Amit Lal versus so-and-so, a two-judge bench of this court dealt with the provisions contained in the Rajasthan Medical Services. Prescribed that a candidate for direct recruitment should not have attained the age of 35 years on the first day of January, following the last date fixed for the receipt of application. Rejecting the contention that the cutoff date was arbitrary, this court held that the fixation of cutoff prescribing maximum or minimum age requirement for a post is in the discretion of the rule-making authority. The court held thus. In the first place, the fixing of cutoff date for determining the maximum or minimum age prescribed for a post is not per se arbitrary. Basically, the fixing of cutoff date for determining the maximum or minimum age required for a post is the discretion of the rule-making authority or the employer as the case may be. One must accept that such a cutoff date cannot be fixed with any mathematical precision and in such a manner as would avoid hardship in all conceivable cases. As soon as the cutoff date is fixed, there will be some persons who fall on the right side of the cutoff date and some persons who will fall the wrong side of the cut-off date. That cannot make the cut-off date per se arbitrary unless the cut-off date is so wide of the mark as to make it wholly unreasonable. Then, my lord, I will skip to paragraph 25. In so and so, the Public Service Commission advertised for direct recruitment to the post of Assistant Director in the Central Poultry Breeding Farm and prescribed an age limit of 35 years as on so and so with a relaxation of 5 years for government servants. The earlier notification did not provide a limitation on the age relaxation. The 5 year stipulation was challenged as being arbitrary and ultra-wide. The two-judge bench upheld the notification and held that prescribing of any age limit for a given post is also deciding the extent to which any relaxation can be given if an age limit is prescribed are necessary matters of policy. It is therefore open to the government while framing rules and the provision to Article 309 of the Constitution to prescribe such age limits or to prescribe the extent to which any relaxation can be given. Prescription of such limit to the extent of relaxation to be given cannot be termed as arbitrary or unreasonable. The only basis on which the respondent moved to Central Administrative Tribunal was the earlier rule. Your Lordship may skip all these things. Then, para 26. The Ramachandra Agarwal, the Council of Scientific and Industrial Research, framed a scheme for the absorption of researchers working in their laboratories and institutes following the directions of the school. It was prescribed that eligible applicants must have 15 years of continuous research on so and so. The director was conferred powers to relax the requirement containing that the tenure of researchers is ordinarily 13 years. The prescription of 15 years was challenged as being ultra-wide and arbitrary. This contention was accepted by the High Court. On appeal, a two-judge bench of this court examined the scheme and applicable avenues to researchers. Nothing that there was no ceiling of 13 years on researchers. This court upheld the prescription of 15 years on the cut-off date. The state is entitled to fix a cut-off date. You Lordship has seen that earlier. Then 30, the High Court, however.
No, there is no quarrel with that proposition. Cut-off date, age.
These are all policy decisions.
Those are a different, that's a different issue.
No, why I am citing, my lord. Now, your lordship will find we have relaxed for 5 years. Exactly in this case, your lordship has seen 5 years relaxation is given. Now, these person, some of the petitioner was having, after taking the relaxation, they could have, my lord, participated. They did not. Now, after doing that, can they say you watched the advertisement? For what reason?
No
What is
relaxation,
the arbitrariness?
that education also, qualification also be there. Age is too much.
Can they say all these things? Qualification is a base mark, my lord. It's an hospital, cancer hospital. You must have certain sense of qualification.
But they are working since long, my lord.
That is your fault. You do not have the qualification.
No.
Now, in that way, my lord, your lordship kindly see, if the advertisement, if they want to be interfered, because the relaxation of 5 years, they want, if I am having 40 years, the age limit is 25, I should be given 15 years. That will be arbitrary, my lord. Because there is a limit of giving relaxation. Your lordship will find most of the appeals court decision, the decision of this honorable court. Relaxation, your lordship will find 5 years, and your lordship has respected that.
No, but then they've been working for so long. You have been, it's not that you haven't found their work to be unsatisfactory.
Yes, ma'am. My lord, we haven't ousted them. They are working, and there your lordship kindly see the equity.
So what do you want? You want relaxation of the age and qualification?
My lord, relaxation of age, it will be an impossible because now at present.
What do you want, Mr. Council? Please, what do you want?
It is not their prayer, my lord.
Huh?
Your lordship can see the prayer. Your lordship has seen that. It's not their prayer that this age should be relaxed, qualification should be relaxed.
No.
They say that advertisement should be quashed.
My lord, we have not specifically mentioned any relaxation
Then
regarding matter wise, but we prayed for allowing us an opportunity to appear before the interview, relaxing our qualification and age, etc.
how your lordship will deal with this thing when you are not asking for it? Because your lordship will not travel beyond the pleading and prayer made in the writ petition. That is the only thing. You ask for something and you are, at the time of argument, you are saying.
You see, because one thing is that maybe, I don't know,
You cannot ask for more.
I
did
think
not
you're
ask
not
for that.
listening to me. You're more interested in what you have to say than what the queries will be. The issue is, you have only asked for setting aside the advertisement.
My lord, we are not going to, no, set aside the just modification. In the premises aforesaid, it is humbly prayed that your lordship would be pleased to admit this petition, call for record and issue rules calling upon the respondents to show cause as to why read in the nature of certificatory and on mandamus and or any other date of the order or direction should not be issued to quash, modify the impugned judgment, advertisement.
Okay, now you say, yeah, you have asked for setting aside or modifying. Now, how do you want it modified?
Some relaxation and special.
Relaxation with regard to what?
Special qualifications should be regarding their experience, considering their experience. Long.
Okay,
dedication.
so there should be a preferential clause.
Yes.
Where have you stated that?
You have not mentioned it specifically, but some,
Where have you mentioned it indirectly also? Tell me. Where have you mentioned it indirectly?
For
Not specifically, but
modification.
indirectly. Huh?
published in the assembly with daily details to respect the post of attendant and paid helper. And to allow the petitioner.
The plead and pleading in 226.
And to allow the petitioner.
My lord, it is very
Participate.
specifically because you are to say what you want to say, including what will be your evidence, because in this, my lord, writ jurisdiction, there is not a chance of giving evidence. By way of annexure, you will have to annex.
Finished by.
That is the appeals court is saying. I'm saying about the law, everybody was, we can learn many things. At the time of the
They are
deliberation.
person I have not yet completed. my lord.
You cannot complete, you
No,
don't
no.
have any pleading and you want to argue that.
And to allow the petitioners to participate in the recruitment process for the post of attendant and paid helper by relaxing the age and qualification of the petitioner.
Okay, for the
Yes,
post
they
of
have-
attendant.
Yes, ma'am.
Now, did this advertisement that has been issued, does it call for attendance?
Attendant.
So you want to participate? Okay, we'll allow you to participate. They'll have a separate exam for you, but what do you want?
Some
No.
special consideration,
Like what?
not relaxation and consideration
Like what?
regarding. the-
Black and white, please tell us in black and
considering
white.
Their experience, their age and qualification, these three things.
Okay, but okay, so they should all be allowed to participate. Okay, then next. What education qualification, what? You want to be class 2 pass or what? Class 1 pass, KG pass, what? What do you want? Class 8 pass, class 7 pass? Your pleading should be precise. I think what we'll do, Mr. Data, I think you please bring that the agreement or the some document by which you took over the hospital and regarding what would be the fate of the existing employees. I'm quite sure there'll be a provision there.
I'll see. My lord,
Let us see that. And then, and because you see, they've been working, so that is also some consideration, because for them, now it's very, very difficult to get a new job. I'm quite sure. There must
One
be.
thing I can suggest, my lord, because I have seen many of the appeals court decision in such sort of eventuality. My lord, who can ask the employer to frame a scheme Well, that is the only scope.
Then you can talk to them.
But if they think that they will be ousted, this is an unnecessary apprehension, my lord, we are not going to do. And my lord, since the reference is pending, even otherwise we are restrained to do that statute.
That is there, that is there. No, I understand. But,
My lord, as your lordship suggested, I will try to get those.
yes, you try to get that, and you can also ask your client. If they can give him black and white, that they will not be ousted.
That will ask. And then another thing, my lord, can we see, they should be careful in filing the petition. Here, your lordship will find 4 of the persons, they are not in the institute, they have filed. Can they ask for quashing of the advertisement?
Not in the institute meaning?
Petition number 1, 2, 3, and 12.
What do you mean? They have left?
They have left.
My lord, they were ousted, my lord.
2 are ousted and
2 were
others-
ousted. Someone.
And then the reference is pending for that. as your
Okay.
lordship has seen.
For that, so who has left? 1 and?
1, 2, 3, and petition number 12.
No, but you said 2 of them, that is challenge.
Yeah, 2 of them,
are
1 and
1 and 2 has challenged.
Yes.
So 3 and 12,
3 and 12.
they have left.
He is still working.
He is still working.
What do unnecessarily say? Navajit Sharma.
Yes, Navajit Sharma is working.
My lord, my chief executive officer has said that he is not in service. Anyway, if he is saying, my lord, I will see.
And who is the person who gave his or her candidature but did not turn up for the exam?
That is my lord 14. Vanita Burman.
Correct. Mr. S. Datta, learned senior counsel submits that petitioner number 3 and 12 are no longer working in the hospital. However, they have been made writ petitioners in this writ petition. He also submits that the petitioner number 14 had submitted her candidature in pursuant to the advertisement dated 30/10/2023. However, there is point number 14, petition number 14 did not turn up for the written examination. Full stop. Next para. Mrs. Datta shall submit the terms of agreement made between the hospital and the
My lord, Atomic Energy, Government of India.
Atomic Energy. Atomic Energy?
Government of India.
And the Government of India, Department of Atomic Energy, the
Yes.
Government of India.
Tata Memorial.
Huh?
Tata
No,
Memorial.
sir, that is no. Tata Memorial has come subsequent.
Okay. With regard to the status of the employees in the hospital. As to the fate of the, not status, as to the fate of the employees of the hospital at the time of takeover. So, this is the matter again after 2 weeks.
My lord, further.
3 weeks. No, too heavy.
Better 2 weeks, my lord, because these people are selected, they are just.
We have got too many matters. We are one after the other, your cases. We're having I've got a lot of backlog.
My lord, I understand, my lord, our position is all the same. And in the month of March, a lot of matters fixed. I have stopped going outline benches now because of the heavy pressure here.
Unfortunately, we are only one. We have got a team of juniors.
That is true.
My lord, immediate temporary relief may kindly be extended.
What temporary?
Status quo.
There is a status order.
The status order is there.
Status quo.
That is troubling us, my lord.
Interim order passed today shall continue till the next day.
Can your lordship fix a date?
Okay, fix the date.
Inside. Good night. All right. Much obliged.
you put this.